Appellate Division, Supreme Court for the Department. Please meet all persons having business with the Appellate Division. So here, your attendance and shall be heard. Be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have some 6 hours of argument that has been requested, so I ask that you please bear that in mind when I call the calendar and ask only for the time that you actually absolutely will need to make your points. We have your briefs, we have the record, we are fully familiar with the facts of your case. Okay. First case is People versus Ernest Adams.
Appellant requests 5 minutes on direct and 2 in rebuttal.
People request 5 minutes.
5, 2, and 5. Thank you. Star Pass versus CREF3 SPA is submitted. Jacques A is submitted. Malerba versus New York City Transit Authority.
Appellant requests 5 and 3, Your Honor.
Respondent requests 10 and 2, Your Honor. Respondent requests 2.
5 and 3. 5 and 3 and 2. Vasquez versus Ridge Tool. You said 5 and 2, and you said 3, is that right? Okay. 4 and 2 and 3. Nurlibayev versus Smile Direct Club. Wait, I'm sorry. You are the appellant? Is the respondent here? Okay. Okay, now, why don't you do that again? Thank you. Okay. Good afternoon. Okay? Okay, I'll give you 5, 3, and 5. Thank you. People versus Ruben Lewis is submitted. Masumi versus Ganju.
Yes, on behalf of the appellant, Appellate LLC, I'd like to introduce my co-counsel, Mr. Attorney Norfolk from Washington, D.C. I would be requesting 8 and 2 on behalf of the appellant.
On behalf of respondents, 8 minutes. My name is William Foley from Forest County, Minnesota, and I'd like to introduce James Kramer, my partner, who will be arguing with the court's permission, who has been admitted faulty.
And the time you're requesting? 6, 2, and 6, and I will just say, as one of our senior colleagues likes to say and point out, we have thousands of excellent lawyers here in New York, and while we like to see from time to time lawyers from other places, and we do admit them pro hoc vice, we do have a number of excellent counsel right here in the good old state of New York. 6 and 2 and 6. AIDS Healthcare versus New York City Department of Health. You are. I'll give 6 and 2, 5 and 5. Hoy versus New York State Division of Housing.
Appellant, 5 and 3, Your Honor.
Respondent, New York State Division of Housing and Community Renewal, 3 minutes.
Respondent, 433 West Associates, 3 minutes.
I'm sorry, you said?
3 minutes.
5, 3, 3, and 3. 5-2, 3 and 3, thank you. BJ Children, submitted. Bradbury versus Israel,
Appellant's 8 minutes and 2 minutes for reply, Your Honor. Respondent cross appellant, 8 minutes.
6 and 2, 6 and 2 and 4. People versus Stephen Matthias,
The only issue in this case was excessiveness of sentence. After weeks of haggling, the Department of Corrections finally applied less is more last Friday. He was discharged from parole. The appeal is now moot. We will be filing that documentation with the court electronically later today.
thank you very much. We're happy to hear that. We always like when the parties come to an agreement, so thank you. That will be a submission. Fisher versus Centene Corp. You are pro se, sir? And so the amount of time you would like to argue is what you would give me first. So, I'm sorry? Okay, let me just hear what the other party says before I give you my decision. Sir, time? Well, I was just going to ask what you had to say before I gave my time. You want to know. Okay, I'll give you 3 minutes and 1 for rebuttal. How's that? And you, sir?
4 minutes, Your Honor.
3, 1, and 4. Home Depot versus State of New York.
Claimant Home Depot, Your Honor, 6 and 4.
Give you 6 and 2 and 6. Murphy versus Schmenti Construction.
5 minutes for appellant taking construction and 3 minutes. 4 minutes, Your Honor.
5, 2, and 4. Franco versus Sky East is submitted. Newell versus the City of New York is submitted. First case is People versus Ernest Adams.
Good afternoon, Your Honors. Ms. Richardson is unable to be here today. I'm arguing in her absence. My name is Harold Ferguson. Late last week, Ms. Richardson realized she couldn't be here today and sought a volunteer from our office to do the argument. If I came before this court today and said, I'm not prepared, this case would go on and you would decide it without us arguing it. Or if I came before this court and said, we need an adjournment so Ms. Richardson could be here, again, the court wouldn't entertain that. The case would be decided on the papers. Rules have to apply even-handedly to both sides in the criminal context. Here on April 6, 2017, the people were apprised that the hearing would take place on April 27th. The assigned ADA just doesn't show up on the 27th. The hearing proceeds without her, but in an abundance of caution, the court gives the people 3 weeks to respond in writing or verbally to the hearing.
Does the court, and we know the facts, of course, I know you know that, and I saw where you were going, where you set it up, and I understand. Does the court have the authority, doesn't the court have inherent authority to correct or to allow for something that it wasn't aware of when it rendered the sentence here?
This was, although categorized as a motion to re-argue, is actually a motion to renew. For a renewal, there has to be reasonable justification for the failure to present that material at the time that court was making the decision. Here, there's no reasonable justification. The assigned ADA had notice from her colleagues that this was going forward, and everything that she presented to the court in the renewal application was in her, she had it. She had all of those documents.
That's true for renewal, but what about inherent authority? What about the inherent authority of the court to act on its own?
I don't think the court should have What you would be giving is the opportunity for the people to get around standard rules of the civil procedure law by doing that. I don't think it would be particularly fair for Mr. Adams in this case because, I mean, to the point of the application was created by virtue of an ex parte communication of the assigned assistant district attorney to the court with no notice to counsel, and it ended up delaying the release of Mr. Adams. So this is inherently unfair. So for the court to say that it had the inherent authority to do so, again, that wasn't the court's ruling. The court didn't say that it was acting under its inherent authority to do so. The court said it was entertaining this as either a motion to re-argue or a motion to renew. It did not hold that it was doing this because of its inherent authority to do so. It made its ruling explicitly on that basis. So therefore, this court shouldn't look at this as an inherent authority case or an interest of justice because that's not what the court ruled upon. And therefore, we believe that the appropriate thing was that this should have remained a level 2, and that as a result, we are asking this court to overturn that decision and to readjust it and allow Mr. Adams to be a level 2 sex offender.
Thank you.
Good afternoon, and may it please the court. Your Honors, the SORA court here properly reopened the hearing and adjudicated defendant a risk level 3 sexually violent offender for attacking a woman in an elevator.
Putting aside the underlying facts, when you say they properly renewed, what legal basis for renewal did the trial court have in front of it?
The court had
Justified renewal under these circumstances.
So the court had the authority to reopen the SORA hearing.
I'm not asking about its inherent authority. I'm asking for, as a matter of law, given the standards for renewal, what standards of renewal did this application meet?
So under CPLR 2221E, it's based on new facts not offered into the prior motion. And here, the people provided a reasonable justification for that.
And what was the reasonable justification? Weren't those all facts that they had known since day one?
Yes, however.
So what was the reasonable justification for not having made that application initially?
The reasonable justification, as the lower court found here, was that the people did not know that they were seeking and contesting those points. While it's true that in a prior hearing where the assigned EDA was not there, that discussion began. But in in her sworn affirmation, in her motion, she noted that she did not know that, she did not have that information, and the court, understanding and having the history that she was at trial on numerous occasions, took that into consideration and found that to be reasonable justification here for her not to know that information, that it was not being contested.
Isn't the reasonable justification for the court's error? Don't we look to the court's error? There was no error that the court had made to here. And in fact, even if we look to there was no error at all because the people had the information.
Yes,
and there was no overlooking. I mean, the assistant just didn't show up.
Well, she was at trial, and the court noted that specifically during the...
I understand that, but, this was not a trial itself. It was you could pass this information along. I think ADAs are pretty, quick studies, enough to have put this together to be able to present it to the court. So it really is an oversight, the opportunity to correct an oversight on the part of the people that cost the defendant an extra 6 months of incarceration.
Well, it's the job of the court, even if the people made an oversight here, to correct that, given all of the information that they had.
So how often where does that end? So the next time the people remember it 6 months after the defendant has been released, and we can recall it to say there was something we should have presented at the SORA that we didn't, so please take a look at this because this person is out. in a level 2 and he should be a level 3? I mean, where does that stop
Well,
when we allow it for the people to come back for really no good reason other than they weren't prepared?
In that situation, it would have been completely different. Here the ADA immediately went back within 6 days, the motion was in, and within 9 days, all parties had come together to reopen the SORA hearing and examine the information.
I'm sorry, when you just said the ADA immediately came back, the ADA didn't show up twice.
Well, prior to the determination, the ADA was on trial and was noted to not be there. But after the determination on May 31st, on June 6th, the motion was filed by the people, and on June 9th, the SORA court was reopened. So immediately with that new information, the court reconvened, and based on that, determined that they were in fact strangers. And the court even noted this prior in an April 27th hearing that the information that they knew each other was incredible and not worthy of belief. And that's on page 5 of the April 27th minutes. So it's reasonable in that light that the assigned ADA was under the impression that the application was only about the downward departure at that time.
Yeah, but no, you know what? That was made clear too. That I'm not sure if my colleague mentioned this, but that was made clear at the first hearing that the ADA, I think, showed up or didn't show up, but that was made clear. It was not a surprise, and it certainly by the second time, everybody was aware of what was on the table to be discussed. So, but I have this question for you. There's a case that the Court of Appeals granted leave on, People versus Weber, seems to be W-E-B-E-R, which has to do with the Appellate Division 4th Department sending something back down so that the prosecutors could consider an upward departure, and then it comes back up and it's appealed. There's a leave on that. Is this a case we should hold pending that decision from the Court of Appeals?
I'm not entirely familiar with what the court is considering in terms of that leave application, but here I think it's clear that the court had the ability to apply the guidelines and had all of the information almost immediately in order to make a proper determination.
Thank you.
Thank you.
There is no reasonable justification here for the people to get up here and argue that the AD was unaware and contended that she was unaware that we were challenging the points. As of April 27th, she certainly knew that. And to say that her colleague who stood up for her on that day, participated in the hearing, did not impart any of that information to the assigned ADA it borders on the ludicrous. If you send your colleague in, you have an affirmative obligation to ask your colleague what happened in court. And that didn't happen here, at least that's the argument. They were given 3 weeks, and even if she's on trial, she had 3 weeks in which she could have submitted written submissions. Everything was in her possession. So therefore, there was no reasonable justification. And as to Justice Renwick's question regarding Weaver, this court took this position in Tadell Sanford. Because it was the same issue, and Hassan Murray, which was the co-defendant, is going up to the Court of Appeals. This court has not issued its decision in Sanford pending the resolution of Mr. Murray's appeal. In light of Weaver, it would be fine for this court to hold off to see how the court is going to rule on that, notwithstanding the fact that the calendar is set through May, and Weaver will not be heard until sometime in the fall.
Mr. Adams is released, isn't he? He's not being held.
That is correct. He ended up serving an additional 6 months.
6 months.
And it placed the defense counsel in a terrible position. She had 2 days, maybe, to prepare for this reopening based on an ex parte communication by the district attorney to the court attorney of the judge. And if she had asked for an adjournment at that point, she knew that would make Mr. Adams stay in prison until then. So it's a level of unfairness here. And what we're asking this court to do is apply the rules even-handedly to both sides. It wouldn't have worked. We could not have made a reasonable justification argument with the similar facts. They shouldn't have been allowed to do that in this case. Thank you, Your Honors.
Thank you. Thank you both. Malerba versus New York City Transit Authority.
May it please the court. Good afternoon. My name is Kevin Pinter, and I represent the appellant EA Technologies / Petrocelli joint venture. This case involves an on-the-job accident which started out as a workers' compensation claim and should rightfully die its final death as a workers' compensation claim. Simply put, there is no...
That's an unfortunate choice of language in this kind of case, but proceed, counsel.
I apologize, Your Honor. This is a case where my client, the joint venture, hired a subcontractor, Amaron, to service the halon tanks that were part of the New York City fire suppression system. The plaintiff, admittedly trained by Amaron on how to service those tanks, and having done this for an excess of 2 years, was hurt on the job at Amaron's facility, having been trained by Amaron under the exclusive...
Amaron wasn't an authorized dealer for these. As I understand it, the company that made these had a very specific system for authorizing entities to operate them, but Amaron was not within that category, correct?
Amaron was an FAA-approved...
That's not what I asked you. Was it
servicer of
approved
tanks.
by Ansel, the manufacturer?
As of the time this accident happened, there were no longer companies servicing these tanks that could be...
Was it ever authorized by Ansel to use these tanks?
I don't know that it ever sought approval and authorization to service the tanks, Your Honor. The fact of the matter
The
is...
answer is no.
I'm sorry?
So the answer is no,
The
correct?
answer is no, Your Honor.
Thank you.
They had been servicing these tanks for an excess of 10 years without incident. Plaintiff himself had been servicing the tanks for 2 years. The joint venture had no obligation to, and no duty to the employee of a subcontractor to provide a safe workplace, to provide safety equipment, to provide proper training on how to use the tanks.
But wasn't your company servicing those tanks? And you were picking them up from the Transit Authority and taking them over to Amaron. And there was testimony even from a witness from your client, I believe, a lead technician, that the caps, those safety caps, were regularly removed, and sometimes he saved them to have extras. So isn't there a question of fact about whether or not they were delivering them appropriately? Because at some point, I think Amaron said, we're not going to take them unless every single one of them is capped. So it seems that there was a problem there in the delivery that could have, in the chain of the work that was being done there.
I would say no, Your Honor. Importantly, Amaron delivered these tanks, not the joint venture. Charlie Hazelton, an employee of Amaron, picked up the tanks and delivered them to the joint venture, and Hazelton testified, I did not deliver any tanks that day that did not have a cap.
Maybe this was asked already, but...
What about Gustavo Velasquez?
I'm sorry?
Gustavo Velasquez was your employee, correct?
Correct.
And he removed the tanks from the interior of the token booths?
He said he had, on occasion, removed the safety caps.
And in addition, he took off the safety caps and then gave them to Amaron, correct?
Correct. And Amaron had extra caps at its facility. The fact remains that after this accident, the safety cap was found after the OSHA investigation the next day behind a cabinet some 7 to 10 feet away.
But that doesn't mean it was necessarily properly attached to this tank. We have no idea what the relationship is between that, the fact that the cap was found, and what the incident was.
Agreed, but there will never be any evidence as to whether that cap was on the tank or not, because plaintiff can't remember the accident at all. The only evidence I missed.
Because the injury was so severe.
Because the injury is severe.
And also, I believe there was some testimony about threading when the caps are not properly threaded. So if you would put your mask all the way up, thank you. I think there was some testimony about proper threading in this. So even if the cap was on, if the threading wasn't proper, there would be an issue.
Well, there was some testimony that the cap was damaged and I believe scraped when it was found. But the only testimony we have regarding what shape that tank arrived in was that Charlie Hazelton said, I delivered only tanks with caps that day, and we weren't allowed to deliver tanks without caps. I see that my time is up, Your Honor.
Thank you. Counsel, I believe you asked for 5 and 3, but you don't have a cross appeal here. So you don't get rebuttal. So it's 5 minutes.
Thank you, Your Honor. Josh McMahon for the plaintiff from Weitzel Luxembourg. Your Honor, the JV breached their contractual obligation here, literally and figuratively launching an instrument of harm that caused severe injuries to the plaintiff under well-established law that permits a suit in negligence.
Counsel, you also invoke regulations and statutes as evidence of negligence, violations of those. And the JV says that, no, those are trumped by the public authorities law. Would you respond to that argument?
Yes, Your Honor. First of all, Your Honor, the public authorities law only exempts the authority from complying with local laws that conflict with its provisions. There's simply nothing in the New York City Fire Code that conflicts with the provisions of the public authorities law. And Your Honor, in any event, this court previously in Huerta v. New York City Transit Authority 290 AD 2D 33, 2001, determined that the New York City Fire Code is not preempted by the state's grant of power to the transit authority as set forth in that law. That is one example, Your Honor, of the contractual breach here and evidence of negligence. The other is by failing to employ individuals and by failing to ensure that Amron employed individuals that had proper training and qualifications. The record is replete with evidence concerning what training and qualifications were required. At the very least, that training and qualifications required manuals and product bulletins. We know we know that Amron, and we know that the JV did not have those manuals because they were not an authorized distributor. They were not a certified refill station. They couldn't have had them. We also know from testimony from the various individuals and employees in this case that they did not have manuals, that they did not have proper training. Gustavo Velasquez, an employee of the JV, was responsible for performing maintenance and inspection work. He testified they had no formal training and they had never even seen an ANSEL manual. Testimony from Amron employees likewise established this. Peter Malerba testified, the plaintiff, that he had never received formal training or product manuals. In fact, he said that he learned things on the job. Joseph Cardella, an Amron employee who was responsible for training other Amron employees, testified that there were no manuals instructing employees how to service the tanks, that his own training was done on the job, and that neither he nor any other employee at Amron had ever received any training or instruction from ANSEL, something that an ANSEL employee had testified was also required, that training was supposed to be given by ANSEL to authorized distributors and certified refill stations. Anthony Reyes, another Amron employee, testified that there was no classroom instruction or written materials. Instead, he learned by watching. Charlie Hazelton, who made these deliveries, said he never saw an ANSEL manual. With respect to opposing counsel's point about Amron being responsible for making these deliveries, it should be noted that the record contains evidence that tanks that were taken out of the station booths by the JV were placed in closed boxes before they were transported back to Amron's facility. And therefore, Amron and Mr. Hazelton in particular would not have been able
Counsel,
to.
despite all of this evidence that you just cited, OSHA did an accident report, correct?
My understanding is that they did, Your Honor, yes.
And what, you haven't seen it?
It's in the record, Your Honor, yes.
So they found no violations observed. That's a quote. So what do we make of that?
Your Honor, they found no violations. I would argue, however, that the evidence of negligence in this case, based on the two mentioned contractual violations, is clear. This is an over 3,000-page record. There is, as I said before, an abundance of testimony that establishes several breaches, not only of the New York City Fire Code, but of the contract that the JV willingly entered into with the authority that mandated proper training and qualifications in accordance with Ansel's product manuals. That is simply not what happened here.
Isn't that the sort of thing that OSHA would look into, though?
OSHA is not a part of this case, Your Honor. I guess I can't speak to their finding or its right or wrongness.
There was one reference in the OSHA report that confused me, which is that they said there were no eyewitnesses. Did Mr. Hughes testify that he did observe the accident, or am I mistaken?
My understanding, Your Honor, is that no one observed this accident. No one observed it. The last thing Mr. Malerba remembers is coming home, or coming back to the office, coming back to the EA Tech area at Amaron after lunch, and he began working on the JV tanks.
I guess Mr. Hughes, maybe, but Mr. Hughes said that he was present when the plaintiff was injured. Does that mean that he didn't witness it, but was present? And he said he saw the tank that injured him. What does that mean?
Your Honor, my understanding is that there were several employees at Amaron that day. There was one employee who testified that he heard a boom. There was another employee.
So you're saying he was present, but he did not witness it? That's
Yes,
what
Your
you're
Honor.
saying? Okay.
Yes, Your Honor. There is evidence.
Any further questions from the bench? No. Thank you, sir.
Thank you.
May it please the court, Brandon Rosen, on behalf of third-party defendant, respondent, Amaron Global, Inc. Amaron submitted opposition in the underlying motion as well as the brief before the court for the sole purpose of contesting arguments that they were not qualified or any perceived negligence related to maintenance of the subject fire suppression system. Amaron joins the appellant's arguments that plaintiff and Amaron were well qualified to perform the work, and in addition, that
Isn't there at least an issue of tribal fact about that, given that Ansel did not certify Amron?
I'm sorry, can you repeat that?
Isn't there an issue of tribal fact about Amron's qualifications, given that Ansel did not certify Amron?
That's correct. Ansel did not certify Amron, but Amron was FAA certified, which I would argue is...
Isn't that a whole other kettle of fish, though? That has to do with airline fire suppression, not this fire suppression.
Correct. Amron was not certified by...
Why does it matter that they're FAA certified, then? We're talking about a different kind of fire suppression here.
Correct. They are similar, but they're different. The FAA did certify Amron, but they're not certified by the manufacturer. With that said, Amron nonetheless had serviced these tanks for over 11 years without incident. They made sure
That doesn't make them, that may mean that they're lucky, but it doesn't necessarily mean that they were fully competent to do the job they were doing. I mean, since Ansel had a process for authorizing distributors and certifying refill stations, and your client was neither of those, isn't that at least a question of fact that has to be addressed?
I would argue, Your Honor, that's a red herring because plaintiff was trained to properly maintenance these fire suppression systems. If there's no other questions, that's all the time I have.
Anything else? Any further questions? No. Thank you, sir.
Thank you.
I think you have something, counsel. On the issue of whether there were witnesses to the accident, Michael Hughes was in the building. He came on the scene in the room after the accident, so there were no eyewitnesses, Your Honor, to the accident. I want to address briefly the idea that there was some special certification or qualification needed to service these tanks. There's no expert support on the plaintiff's side for this argument, for this theory, that you needed a master fire suppression license or some kind of a special certification to service the tanks.
But do you dispute that Ansel had authorized distributors and certified refill stations, neither of which your client qualified for?
Neither of which my client qualified, true, but the TA hired my client and had been using them for 20
Sorry,
years.
who hired? Well, I understand, but the fact that the TA hired you doesn't necessarily mean that you had the right skills to do the job.
That's possible, Your Honor. But in terms of proximate cause and the certification argument or the fire license argument, the plaintiff admitted that he knew full well how to service these tanks. He said he knew to never touch a tank without a cap on it. He said, I had been trained by Amaron how to do this. He'd done it for 2 years without incident. And he can't tell you, he can't tell anybody what caused the accident. The public authorities law, which I wanted to address, is really a question of jurisdiction over the TA. And can they dictate what licenses are necessary? So from 1268, 1266, parentheses 8 of the public authorities law, quote, except as hereinafter specially provided, no municipality or political subdivision, including but not limited to a county, city, village, town, or school, or other district, shall have jurisdiction over any facilities of the authority, that's the transit authority, and its subsidiaries, and New York City Transit Authority and its subsidiaries, or any of their activities or operations. So jurisdictionally, this idea that we needed some special certification or master fire suppression license, it's just not true. And there was no expert hired to put forth that argument. And I think there was no expert hired because it's not a valid argument. There was no requirement for this license to service the tanks. And my final point would be there is an enormous proximate cause issue. Even if we assume Amaron should have had a certain license, the joint venture should have had a certain license, where is the nexus between the lack of that license and causing this accident? I submit there's no evidence whatsoever that one had anything to do with the other when there are a number of other possible causes for this accident.
Thank you, sir.
You're welcome, Your
Thank
Honor.
you all.
Thank you.
Vasquez versus Ridge Tool. Justice Moulton is recused from this case.
Good afternoon. May it please the court. Patrick Lawless for the defendants' appellants, Ridge Tool and Home Depot. At the very least, the court below should have dismissed all claims against Ridge Tool. The evidence in the record, which was undisputed by the plaintiff in the court below, shows that Ridge Tool did not have anything to do with the manufacture, design, or distribution of the router that was used in the accident. The plaintiff identified the router as a rigid model 2401. The testimony in the record shows that all of these models were manufactured by a company known as One World Technologies, exclusively for Home Depot, and Home Depot was the exclusive retailer of that model pursuant to a licensing agreement.
And you said, counsel, that there is nothing in the record that says otherwise as to that aspect, that RT or Ridge Tool ever sold this particular.
Yeah, it's never been refuted in a record, and as a matter of fact, the parties actually stipulated as to this model and that this was sold exclusively by Home Depot. So at the very least, because Ridge Tool is just merely a licensor and had nothing to do with the sale, manufacture,
So
distribution.
could you go on to the failure to warn? There were two different claims for failure to warn, correct, in this case?
Yes, there's one based upon the operator's manual, and then there's just the standard failure to warn claim. And with respect to the failure to warn claim, the case law is clear that there are two bases for dismissal of a failure to warn claim. If the injured plaintiff was a knowledgeable user, and if the risk was open and obvious, and both apply to this case. The plaintiff had testified that prior to this incident, he'd handled numerous power devices and was well aware that he could be severely injured if his hand came into contact with the spinning blade while the two was being operated. He'd used this specific router on a prior occasion, was aware of its cutting ability, and in opposition, and in contradiction to what his testimony is, the plaintiff claims and his expert claims that that the plaintiff wasn't aware of the specific risk of amputation, but that's not what's required. What's required is the overall risk that he could be severely injured if his hand came in contact with the blade.
And it's not an issue of fact in this kind of case as to whether it was reasonable for him to have said, I had the experience, or if there's any question about how much experience with this particular type of tool he would need to find him a knowledgeable user?
Well, he'd had extensive experience with other types of power tools. He used this on one prior occasion and was clearly aware of its cutting ability.
Well, I mean, it's a saw of some sort, so I would think that everybody would be aware of its cutting ability. That's what it's there for. This is a specific kind of power tool, and it got stuck on something, and it kicked back. I think really, does one have to have the expertise with regard to this kind of tool and all of its foibles? I mean, that it can actually kick back on, and cause injury in that way. Obviously, I mean, the average person on the street would know that you can't put your hands in front of a saw or a power tool. So, that's when it comes to what level of understanding are we talking about here and knowledge.
Well, actually, if you look at his own testimony too, he says, and it's an admission by him too, the reason why he kicked back was he was using it on an unstable surface.
Well,
I think it was
I'm sorry. I understand that it was on a bucket, but the reason it kicked back was not because it was on a bucket, but because it hit a hard knot in the wood, I thought.
Well, he said, he basically admitted that it was his fault because he wasn't using it on a stable surface.
But that's different from whether or not that was the cause of it. And the question is whether your manual indicates that when it hits a knot, it can kick back. And at least there's a question of fact as to whether the reason it kicked back was because it hit a knot, not because of what surface he was using it on, correct?
I wouldn't say that it was an issue of fact because of that. I think overall he was aware of the risks, and he'd been using this on a prior occasion, was aware of his cutting ability.
He'd only used it since working on this particular project, correct?
Yes. I see my time is up. I'll address the other issues on rebuttal.
Thank you. We have a demonstration.
May it please the court. Good afternoon.
Good afternoon.
I represent the plaintiff respondent, and I brought the device because I wanted to make sure Your Honors had a full, complete understanding what it is. It is not a saw. If you take a look at it, if you want, I could pass it to your officer. It's up to you. There's a picture in the record.
Yes, there is a picture in the record.
I just wanted to make sure this is the actual device that was being used.
Yes, okay.
Now, again, that's
So when you say it's not a saw, isn't that a piece of metal, a round piece of metal with corrugated edges, right?
Correct, Your Honor.
Okay, and it spins around, is that right?
That is correct.
So it might not be a straight saw, but it's a circular saw.
Your Honor, I wouldn't have classified it as that, especially if you're...
Cuts things, doesn't it? Like It cuts things.
It does,
Yes,
but if you take
okay.
a look at the
I,
plastic around it,
I don't need to see that more than we saw on the record.
not a problem, Your Honor. My point is, as you handle it, you can clearly see that you would not initially, if you held it in your hands, go, oh, I could cut my finger off with this. And I don't think that would be a reasonable way to look at it, especially given the way it has this plastic thing around the top. Something would radically have to happen to kick back. And if you look at the manual, it warns not of a risk to cutting anything. It talks about your eye protection being needed. It doesn't talk about the risk to being cutting your finger off at all. And get to the correct point, he doesn't have extensive use of machines like this. He had only used it one time before. So he had no
And
knowledge.
What about the fact that he had been doing this type of work for quite a while? I think he said since he was very young. And so he didn't have any experience over all those years with this type of,
I would respectfully disagree, Your Honor, but you use saws. When you use basic saws, they have the big metal things that go around, and you know those can cut your hand off. They have pictograms that tell you that, as this clearly does not have.
Can
on any part of it.
Can I ask you another question about the manual? Because that's also one of the claims here, and I thought that there was different testimony in the record. I'm not sure if anybody saw the manual here. Could you tell us how you evaluate the testimony in this case? At this point, the record.
What had happened was, Your Honor, that was never exchanged during the discovery. We only saw the manual for the first time when we had motion practice for summary judgment.
Was there a manual the day that the plaintiff was using that?
No, but as you can see from his...
Was he given a manual at all?
No, he was not, Your Honor, and he said if he was given a manual, he would have read it.
Did anyone testify that, did the employer testify that they gave them manuals to look at, or that they ever saw the manual? Was there any testimony about that?
No, there was no testimony, affirmative testimony that the manual was ever made available. He was given the machine and told to use it.
So you're saying that it wasn't produced by the defendant until the summary judgment motion practice? You said that the manual was not produced until you were in the midst of a summary judgment motion,
That is correct, Your Honor. It was the first time. And as we indicated, once we saw that, we got an affidavit from our client to make it very clear that had he seen that, he would have requested if he knew there was one unavailable.
Can I just ask one?
Go ahead, Your Honor, I'm sorry.
Well, I just wanted to ask one other question. There's some discussion in the record about whether or not your client was fluent in English or not, whether he could have read something in English or understood something in English, but whether it was a manual or an affidavit. What did you show in the record in terms of your client's ability to communicate and read in English?
In English, he understands basic because he works construction sites, so he has to be able to understand directives that are given to him from his workers.
Did he testify? He testified with an interpreter, I think.
I believe he did, because to be honest with you, Your Honor, when I have witnesses that I put forth for deposition, I told them to testify in the language that they're most comfortable in, Your Honor. And that's his first language, so I would always tell my clients to testify in their first language.
I had a question about.
Go ahead.
I have a question about Ridge Tool. I gather you're asking that we keep Ridge Tool in the case, but it seems to me that you stipulated at page 520 of the record that Home Depot was the exclusive retailer of this router. Given that, given that you stipulated to that, what is the basis for any claim of liability against Ridge Tool?
I think the problem is at the time of when you're making a motion for summary judgment, you bear the burden of proof, and you have to demonstrate before the court that you're entitled to it.
But
They didn't bring that before the court, number one. And number two, does that necessarily exonerate Ridge Tool completely from being involved? The court made its decision, and I respectfully will stand by it for obvious reasons.
I'm sorry, but I still don't understand what it is that you believe would make Ridge Tool liable, given that it was not a retailer and essentially was just a licensor.
Again, that's their representation that they put forward, but it's got to be complete. They have to state that they're not involved in the manufacturing process at all. And I didn't see that in the record, and Judge Billings didn't either. And neither did Judge LaBelle.
Thank you.
It went through two judges, Your Honor.
Was there another question? No. Okay, thank you.
Thank you.
Just very briefly, the argument that counsel just made, he's precluded from doing so because he never opposed it below. Again, he not only did they stipulate that the router was exclusively sold by Home Depot and that Ridge Tool didn't have anything to do with it, but he actually incorporated those arguments into his summary judgment motion. With respect to the operator's manual, the evidence and record shows that all of these devices were provided with an operator's manual. The plaintiff's employer acknowledged that it came with paperwork, but it was never provided to the plaintiff. And based upon that, they can't be...
When you say paperwork, are you specifically referring to a manual? Is there testimony?
You said he can't... Well, you have two things. You have the affidavit of Mr. Winchester saying that all these models are sold with the manual. They all come with the manual. That's not refuted. Then you have the plaintiff's employee who admitted he was asked, did it come with the manual? And he said, yeah, it came with paperwork. But the manual was never provided to the plaintiff. It's never been refuted that all these routers were sold with the manual and that his employer acknowledged that it came with paperwork. What other paperwork would it come with?
Counsel, many tools have some kind of warnings directly on the tool itself, often in a graphic form. There's nothing like that on this router, is there?
I don't believe so, but the claim, the failure to warn claim, is based upon that the operator's manual was insufficient.
I understand.
And he was never provided with one. So based upon that, that particular claim should be dismissed. And I'll just move on to our last argument, which is the design defect claim based upon the failure to interlock. They didn't present, there's no evidence in this record that an interlock would have been viable or that other similar devices were provided with an interlock. And generally speaking, the law says...
There's a question. There's a question.
Wasn't there an affidavit from Mr. Pugh concerning the interlock?
There was an affidavit, but there's no support. It's just a conclusory statement in his affidavit, and there's no support about other devices or about whether it was viable or whether it would interfere with the functionality of it. And generally speaking, the case law is that just the bare claim that the failure to interlock cannot support a design defect claim. Unless you have any further questions, I'll just rest on my brief. Thank you.
Thank you both. Nurlabayev versus Smile Direct Club. You may begin.
Good afternoon, and may it please the court. Yuri Kolesnikov from Butini, on behalf of plaintiff appellant Rustem Nurlabayev. Distilled to its core, this appeal presents a discrete issue for the court, whether the trial court should have stayed rather than dismissed this class action, where it's undisputed that the complaint names two defendants who are not parties to the related Tennessee actions. The statute of limitations for bringing the class claims has already expired, and there's already a related state action pending in the trial court bureau.
But won't that, any action here would be governed by the same law as the action already pending? So if that one lost, why do you think that you would, if the action were stayed and the plaintiff lost that case, why would you think that you would have any likelihood of success here?
Well, actually, that's a very good question, Your Honor. And just this morning, we were notified by defense counsel that there was an opinion in the Tennessee Court of Appeal on the classification issue. And what the court did in that case, it's affirmed, but in part, it dismissed the Section 12 claim in the Tennessee state court action on the basis that the Tennessee state court plaintiffs lack standing to assert that claim. Mr. Nurlabayev purchased his shares in the IPO on the date of the IPO at the IPO price. So unlike the Tennessee state court plaintiffs, he has standing to prosecute Section 12 claim. So if before it was hypothetical, now we have a decision from the Tennessee Court of Appeal
But that's not before us, right?
Correct. We were just notified this morning of this, Your Honor, and defendants knew about the decision for 2 weeks, and they did not apprise us until early this morning. So with the court's permission, we would like to put that decision in the record. It was issued, I believe, on March 18th, 2 weeks ago. And again, we were just notified of that this morning. But what happened in that case is the court dismissed the Section 12A claim. So there is no certified class now on behalf of Section 12A claim purchasers. So this is one scenario.
Counsel, there's a federal case too, isn't there, in
Correct.
Tennessee?
There is a motion to dismiss pending in that case. And again, we don't know if that case will get dismissed or if the court in that case will also not.
Did your
certify.
client seek to participate in the class representative procedure in the federal court in Tennessee?
I'm sorry, can you repeat the question?
The federal court has a procedure to determine who's going to be the class plaintiff, correct?
Correct.
Did your client participate in that process?
He did not.
Why not? In other words, that's a way for him to make himself a class plaintiff just in a forum that not necessarily of his choosing.
Well, no, Your Honor. The Supreme Court in Science said Securities Act plaintiffs can file in state court, the federal court. So the client, as a matter of his complaint, has the right to proceed in an appropriate forum in state court, which is not subject to PCLRA plaintiff lead counsel provisions. So while it's possible he could have, but he doesn't have to, he has a right to file in state court, which he did. And he relied on the fact that there is another related case which defendants did not move to dismiss, thereby demonstrating there is no additional burden, no prejudice in staying to preserve the class claims. And again, this is not a hypothetical issue anymore. The statute of limitations for class claim has expired. If the federal district case is dismissed, this New York action will protect the Section 12A class and other purchasers who purchased in the IPO to represent that claim. It also has two additional defendants, which are not parties, named in the Tennessee actions. So again, we would submit that under this court's decision in safeguard,
are the damages any different under 12A than they would be under Section 11, Section
yes, Your Honor.
15?
So,
they would be different damages?
Yes, so the Section 11 is you take the IPO price, even if you bought it above the IPO, you cannot recover the difference, and you subtract from that the price at which you either sell the stock before suit commenced or the value of the stock at the time the suit commenced. Under Section 12, what you have is you can rescind the transaction. You can tender the stock back to the company and get what you paid for it. So right now, when FDC Smile Direct Club is trading at $2 a share, that's a very lucrative option for the shareholders. If they win a trial, they'll be able to, as one remedy, to rescind the transactions, tender the stock, and get back potentially up to $23 a share that they paid for FDC stock.
Can that be done in the Sasso litigation as well?
There is a Sasso litigation as well, correct.
So you could also get that same relief in the Sasso litigation, correct?
Again, we don't know if the Sasso plaintiff purchased in the IPO at the IPO price, so he also may not be an adequate representative on behalf of the Section 12A2 class, Your Honor. I see my time is up.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Michael Griffin from Skadden Arps on behalf of the defendant respondents.
So, counsel, I just want to ask you, it seems that the plaintiff focused on the fact that even if the court were correct in granting, looking at what was going on in the other cases, there should have been a stay rather than a dismissal because there might be some claims that, that could exist here that might not be able to exist somewhere else. So why would the court should not have made a determination of staying it and then see what happens rather than dismissing it outright?
So the trial court was well within its discretion to make that decision. And a stay is appropriate or was inappropriate here compared to dismissal because Mr. Nurlibayev's claims had already been dismissed once by yet another court who told him that if he wishes to participate in these securities class actions or wishes to bring a claim of his own, the place to do so is in Tennessee. And if he wanted to file another action after Michigan, he could have done so in Tennessee. What he could not do is ignore the Michigan court's ruling and turn around and file that same case, the 10th such case, in New York courts. And merely staying the case does impose a burden on all the parties. It imposes a burden on the court. There is a burden of monitoring that decision. For example, in the Sasso case, we have been providing 60-day periodic updates on the status of all of the other actions. It can also impose significant burdens if we were to attempt to resolve all of these cases collectively. It's someone else who needs another seat at the table, which is another voice. And it just goes against the entire purpose of having class actions, which is to appoint a single lead plaintiff or group of lead plaintiffs, a single lead counsel, and to vest in them the authority to make decisions about the conduct of this litigation. And in this case, that's exactly what happened, as Justice Moulton alluded to in the federal action. And Mr. Nurlibayev did not seek to participate in the federal action. He did not seek to participate in the state court action in Tennessee, where a class has been certified, and that case is proceeding on the merits. It's in the middle of discovery right now, and there will be a decision on the merits in that case. So the flip side of the burden question on the stay is, to what end are we staying the case? We are now going to have a decision on the merits at some point in Tennessee, be it from the certified state court action, or if the federal court action survives the pending motion to dismiss there. There's simply no end served by staying yet another case here. And even if there conceivably were some end in having a stayed case in New York, we already have one. We have the Sasso action that asserts the exact same claims Mr. Nurlibayev seeks to assert here, including the Section 12 claim that was recently dismissed in the Tennessee State Court action. It was filed on a day when the stock price was even lower than Mr. Nurlibayev's action. So while we completely disagree that the damages would be any different here versus in the Tennessee State Court cases, even if you were to credit that argument, the Sasso action would be the best action for that argument, not Mr. Nurlibayev's. But of course, and we cite various cases in our papers on page 27 to 28, you can't simply game the damages calculations in a securities class action by date shopping. You also can't game them based on which claims you recover under. Justice Moulton, to your question about Section 11 versus Section 12 damages, counsel is correct that the calculations are different. Kind of the theory of rescissionary damages versus the Section 11 formula are different. But what you can't do is recover duplicative damages under both sections. So to the extent that the class recovers under Section 11, for example, it could not recover, again, duplicative damages for the same claim, for the same harm under Section 12. Those are mutually exclusive. Counsel for the other side also mentioned the Cyan case that allows us to be before your honors in these type of federal securities litigations. What Cyan did not do is authorize duplicative actions in state and federal courts across the country. We already have a duplicative state and federal court action being litigated in Tennessee. So to the extent Mr. Nurlibayev had a preference for litigating in state court as opposed to federal court, he had that option in the Tennessee action. And he chose not to participate in that action, just as he chose not to participate in the federal court action. And that's what the Supreme Court in the China Agritech case said, is that you don't get successive bites at the apple for class claims. The idea is not to preserve successive class actions, but to prevent them. And I see my time has ended.
Thank you.
Thank you.
So I'd like to start with what counsel just ended with. The idea is to preserve class actions, not to do second bites of the apple. If the federal action is dismissed, Section 12 shareholders will not have any bite of the apple of proving the claims. Therefore, this action is necessary to preserve the opportunity. And we're not asking for duplicative recovery. Section 12 allows for people who purchase in the IPO, at the IPO price, potentially greater damages. They can rescind and get up to $23 a share. They should have that right if the federal action fails to go to class certification. So, as this court noted in Safeguard, the appropriate action, when there is a possibility that the other action will not afford full relief to the plaintiff, is to stay rather than dismiss the New York action. This is what we urge the court to do in this case. Stay this action to see how the federal action in Tennessee plays out. If the federal action in Tennessee is also dismissed, this may be the only place shareholders who bought in Smile Direct IPO can recover for Section 12A damages. And going to the Sasso action, again, we don't know if the plaintiff in Sasso is like the Tennessee State Court plaintiffs who did not buy in the IPO and therefore will not have standing to prosecute Section 12A claims. Therefore, the pendency of the Nuremberg action in New York is the only way to safeguard those claims. In addition, as we pointed out in our papers, there's also high damages on Section 11. And there's also 2 defendants who are present in this action who are not present in the related actions. So unless the court has any questions, we would submit that the court should reverse and remand, at the very least, with instruction to stay this action pending the Tennessee action.
Thank you.
Thank you.
Thank you both. Masumi versus Ganju.
Good afternoon, Your Honors. May it please the Court, Whitney Hermendorfer for Appellant Cyrus Masumi. I'd like to start with just a few brief points regarding why the 2018 non-disclosure agreement did not dictate dismissal in this case before turning to the bylaws. With respect to the NDA, all defendants want to talk about is whether Mr. Masumi did or did not have access to relevant company information prior to the request. But that is a factual question that the face of defendants' proffered documents do not address. And for that reason alone, the face of those documents cannot support dismissal under A1, and for that reason alone, dismissal on the basis of those documents was inappropriate. But if we talk about the facts, it actually gets worse for defendants, because all of the company information they rely on, namely, I take them to rest primarily at this point on the bylaws and on the cap tables, all of that information predates Mr. Masumi's departure from the company as CEO and a board member. R28 reflects that in mid-December 2015 is when Mr. Masumi separated as a board of director. That was a month after the board meeting in question, at which amendments 3 and 4 to the bylaws were adopted. And defendants have given no plausible reason why a sitting board member would not have access to information adopted at a board meeting. And indeed, at R188, when defendants raised the NDA as a basis for dismissal, Mr. Masumi responded by saying, "I relied only on non-NDA information when crafting my complaint." So there's a disputed factual question that is inappropriate for resolution at the A1 pre-answer stage, and we are willing to go document by document and make our showing in discovery with respect to his access, which is where factual questions like this are appropriately resolved.
The complaint also facially appears to rely on public information, correct?
That's correct, Justice Moulton, yes. So turning to the bylaws, those also do not support dismissal in this case, because the heart of Mr. Masumi's garden variety common law claim is that defendants looked him in the eye and lied to him and gave him phony documents. That has nothing to do with their status as board members or company officials, and everything to do with violating a law that would apply to any stranger on the street. You cannot tell people affirmative lies in a way that injures them. That's fraud, no matter whether you're a board member or any member of the public. And so because that is the heart of Mr. Masumi's claims, those claims are not, quote, governed by the internal affairs doctrine for purposes of triggering the clause.
With respect to the Amendment 4, of the bylaws. There was shareholder approval. Does that change anything with respect to the venue?
So Justice Shulman, no, that does not change anything. This goes to our second argument for why the bylaws do not support dismissal, and that is because the bylaws are invalid and were a product themselves of defendant's fraudulent scheme. And so under Delaware law, we've cited the Nevins case in reply, for example, a void action, an action that is void ab initio, as we contend the bylaws amendment 4 was here, cannot be rectified by subsequent actions such as a shareholder ratification. And so at the very least, the trial court erred by not assessing and running the validity inquiry prior to enforcing the bylaws forum selection clause. That is a gateway issue, the validity and enforceability of the clause that should have been resolved prior to enforcing the clause. So
And it's your position that he was tricked or deceived into attending the board meeting?
our position is that he was told lies that not only deceived him into attending the board meeting, but also prejudiced his position vis-a-vis other shareholders. And yes, our position is that the fraud was with respect in particular to Amendment 4, because that was part and parcel of the actions taken at the board meeting. So at a minimum, again, vacatur is warranted to allow assessment of enforceability, or the court could hold that the terms of the bylaws themselves do not cover this kind of garden variety claim. Defendants have not explained why a common law claim for fraud against an individual would trigger the internal affairs doctrine, which is designed to apply to relationships and statuses and fiduciary duties unique under Delaware corporate law. And instead, they want to recast the as-pleaded claim for fraud as masquerading as a Delaware law claim in disguise. That's not the analysis the court entertains. The court looks at the claim in front of it, and here all we have is a garden variety fraud claim. I see my time has expired.
Thank you.
May it please the court, James Kramer, Orrick, Carrington, and Sutcliffe on behalf of defendants. R137 says the parties specifically agreed any action regarding this agreement shall be brought only in the Delaware Court of Chancery.
I'm sorry, what are you reading from and reading that?
I'm reading from the NDA, Your Honor, Section 2. Counsel argued Section 1.10, which is a very specific jurisdictional clause, doesn't apply because there's some dispute.
But I think that refers to when the documentation is, is not public or is not already within the, is not already privy to the individual.
That's actually not correct, Your Honor. That's not correct. That's a specific provision of 1.10. There's two provisions in the NDA that require Delaware jurisdiction. 1.10 says if your complaint is based upon, relies on, or incorporates confidential inspection material, you have to litigate that in the Court of Chancery. Counsel's argued the records are public. We dispute that. We made our showing, but that's a red herring because under Article 2 of the agreement, it's page R137, there's a general provision. And the general provision, 137, says each party agrees that any action regarding this agreement will be brought only in the Delaware Court of Chancery. They concede in their papers, in their opening brief.
This agreement, doesn't that refer back to whether or not it's confidential information?
No, it doesn't, Your Honor. And if you look at it, 1.10 says only confidential information covers it, but Section 2 says any dispute. So
arising from the NDA, though, not necessarily from the other governing documents.
I'm sorry, say that again, Your Honor?
That's litigation arising from the NDA, correct?
No, it doesn't say litigation arising from. It says any action regarding.
This agreement.
Regarding the NDA. And counsel has conceded in their opening papers in reply, there's a dispute over the NDA. There's a dispute over whether it applies. Section 2, if it's in there, it has to mean something. It's got to mean something different than Section 1.10.
But then there would be no need for 1.10 if 1.2 required that everything be heard in Delaware. So then you have surplusage in the other direction.
I don't agree with that, Your Honor, because if the parties agreed that something was not confidential inspection material, then you would be full stop, you'd be done. This is a catch-all that basically applies to everything. But I have limited time, so let me
But if
move
it
off
applies
that.
to everything, then why do you need the specific provision?
Because
It
there's
doesn't make
other-
any sense.
There's other provisions in the agreement, Your Honor, that would be beside just the misuse of confidential information. I believe Section 2 applies plainly here. We have a dispute, and I think that's why we're here. But remember, there's two bases to be in Delaware. One, you've got both the NDA, and second, you got the bylaw, the Internal Affairs Doctrine, which, Your Honor,
Amendment number 4 is what you're referring to.
I'm sorry?
You're referring to amendment number 4?
That's correct, which was ratified by the shareholders.
Well, I understand, but what the complaint argues is that amendment number 4 was passed in a fraudulent manner.
And
excuse me.
Yes.
And for the purposes of a motion to dismiss, we have to assume that allegations in the complaint are true. So if we required them to litigate this in Delaware, and if it eventually turns out that you obtained amendment number 4 fraudulently, then you would have obtained the benefit of your fraudulent acts by depriving plaintiff of the jurisdiction that they would prefer to litigate in. Why isn't that something we need to pay attention to?
Because, Your Honor, the nature of the claims there, which involves specifically, and it's not just the passage of the bylaw, it's all of the actions that were taken by the board in connection with not just the bylaw, but by the meeting, which go squarely to the internal affairs. And, Your Honor, it's not just R13, improper changes to governing documents, R36, illegitimate board actions. It's also the remedy, his removal as CEO, which has nothing to do with the bylaw provision. It's a declaration that all of the corporate acts in the last 7 years were improper. They should go to Delaware, and if the Court of Chancery says, you know what, there was fraud, the Delaware Court of Chancery can either apply New York law, or we can come back here. But it can't be that you simply get to allege around a bylaw provision adopted and ratified by shareholders. And, Your Honor, as we pointed out in our papers, Delaware law says when you have a board meeting, you do not need to give the parties a list of all the things you're going to talk about, right? You're entitled to cover new things. You don't have to give any notice at all. So the claim here is essentially that you didn't give us a list of everything you're going to talk about, and you added new things.
I don't think that was the claim. I think the claim was that he was actively misled, which is rather different, isn't it?
So there's conclusions, there are no facts. What they said was you talked about things, you rehearsed the meeting, and you didn't include kicking the CEO out. That's what the allegation is.
That's a big omission, huh?
I'm sorry, Your Honor?
That's a fairly big omission.
Under Delaware law and under this company's governing documents that preceded the meeting, you absolutely can do that, Your Honor. And by the way, Mr.
I thought there's Delaware law that says where a director is tricked or deceived into attending a board meeting, the general rule is that actions taken at such a meeting are void.
He can make that argument to the Court of Chancery, Your Honor. And on this point, we cited the Sang case, Sang versus Silver Dragon, where the Court of Chancery said specifically, any case which alleges misuse of a director's position to commit fraud is governed by the Internal Affairs Doctrine, which is what we have here, Your Honor.
Thank you.
Thank you, Your Honor.
A few brief points. First, regarding Section 2 of the NDA, that section does not apply for the reason Your Honors hinted at. It covers two actions, an action regarding the NDA. Mr. Musumi's action was...
Are you talking about Section 2?
Section 2 of the NDA, yes, at R137, Your Honor. His action was not one about the NDA. The NDA wasn't relevant at all until defendants raised it into their motion to dismiss. And under their view, they can inject the NDA into any garden variety fraud case and win dismissal to Delaware. That's not what Section 2 means. Counsel also raised the remedy here that was requested by Mr. Musumi in his complaint. Mr. Musumi, like many plaintiffs, covered the waterfront in his request for relief. But that does not mean the relief gets to dictate what, quote unquote, governs the content of his claims. And if there is any invalid relief request, that would give the court pause under the Internal Affairs Doctrine, the answer is to excise that relief or allow him to drop it from his complaint. It's not to keep his proper common law claims for money damages out of court. And lastly, the Singh case mentioned by my opposing counsel actually cuts for us, because in that case, the action itself was premised on a violation of a fiduciary duty, and that is why the Delaware statute applicable to corporate officers gave long-arm jurisdiction in that case. We have nothing like that here, where defendants, it's not about notice, it's not about Delaware fiduciary duties, it's about looking someone in the eye and giving them a fraudulent document and telling them an affirmative lie. And that is why his claims are not governed by the Internal Affairs Doctrine, and if anything, at a minimum.
Counsel, you are seeking a declaration, right, that the board is improperly constituted? You're seeking that declaration, right?
Again, Justice Moulton, yes, there was a variety of, in addition to the monetary damages claims.
And that a correlative of that is that the actions taken by the board after its improper constitution were invalid because the board didn't have power to do what it did, correct? That's another declaration you're seeking.
Yes, there is injunctive
How does that
relief.
not have to do with the Internal Affairs Doctrine?
Well, it does not govern the content. It flows from proving his fraud claim. And below, that was the basis at which defendants actually opposed that claim. They said proving your fraud claim is a prerequisite. And so you cannot use the relief that flows from a claim that's proven to then say that governs the adjudication of the claim itself. But Justice Moulton, if the court is concerned about that relief request in particular, Mr. Masumi is more than happy to, as a condition of remand, move forward only with respect to the monetary damages claims, and that's our argument for why he should have been given leave to amend, and it rebuts defendant's argument that any amendment here would be futile with respect to the bylaws form selection clause.
Thank you.
I'd ask that the court reverse. Thank you.
Thank you both. AIDS Healthcare versus New York City Department of Health.
May it please the court. My name is Stuart Klein from the law firm of Bond, Shenick & King, and I represent the appellant petitioner here, the AIDS Healthcare Foundation. I'll refer to them as AHF for short. Hopefully that's okay for everyone. The main question that we're here today to address is whether the Supreme Court erred in failing to find that respondent's decision to deem AHF's proposal in response to the Ryan White Enhanced Data to Care RFP to be non-responsive was arbitrary and capricious. There's a handful of undisputed facts that I think are particularly relevant to understand this issue. First,
well, I mean, the thing with this one is you had like a conditional approval, correct?
Correct. So what we need to look at, I think, is the state of the world at the time that this RFP was issued. So the RFP...
Okay, but their RFP required that you be approved, not conditionally approved, correct?
So the RFP, which was issued in August of 2020 during the COVID pandemic, required Article 28 approval.
Right, and you didn't have that at the time you applied, right?
So technically,
Is that correct?
That is correct.
Excuse me, thank you. I really like it when, I think we all really like direct answers to our questions. So it's correct, you didn't have that approval, right?
We did not have an operating certificate issued by the New York State Department of Health. What we did have was the approval from the Health Planning Council, which was the prerequisite to that final approval. The reason we did not have that approval was because of COVID. So prior to the RFP being issued, AHF did what it needed to do to basically get its ducks in a row so it would have Article 28 approval.
But you never, you did ultimately get the approval from the State Department of Health. But at the time that you submitted the RFP, you did not have that approval.
100% correct.
And you're saying that it was arbitrary and capricious for them not to permit you because you had that pending approval?
One of the arguments, Your Honor, yes. It was arbitrary and capricious for the respondents not to consider the state of the world that we were operating in at that time.
Well, perhaps they did consider the state of the world, and they had to consider what they needed to do to get up to speed as quickly as possible with regard to clinics that were going to be treating AIDS patients and others who needed the care, and they needed to ensure that at the time they made the decision, those clinics would have the proper documentation.
That's a perfectly logical reasoning, but the timeline dispels that, because what happened here is in January of 2021, we obtained our Article 28 approval.
But that's not when they sent out the RFP.
Correct.
We're talking, okay, so.
They sent out the RFP in August of 2020. We had the conditional approval in hand. We obtained final approval in January of 2021, and at that time, they had not awarded any contracts to anyone.
How many responsive applications did they receive, though?
They reference in their papers, but there's no proof in the record. They say the number 11. I do not know anything about those applications. They have the obligation to make the record. We don't have those documentation. So we don't know. We don't know why what those 11 were, why they were granted, why they were denied.
If some or all of those 11 applicants had the proper certification, why wouldn't it be logical for them to say, we're going to focus on those 11 and put aside people who, any organizations that don't meet all of our qualifications, and we'll consider them in the next round? Why isn't that a rational thing to do?
Because what they're doing is they're basically saying that anyone at the time of the pandemic that was trying to get this approval, which we clearly were, we're not going to consider you. All we wanted to do was have our proposal reviewed on the merits. We're not asking for an award. We got basically
Isn't another way of looking at it that they wanted to be able to say, we only want to consider those people who have already been approved, and then we want to take that basket of people and start our process of reviewing them, and we don't want to have to start over when somebody else gets approved. We want to be able to consider those people who met all of our criteria from the beginning. Why isn't that a rational decision?
It makes sense, but you would expect then if that was their rationale, they would have awarded a contract based upon essentially those who had approvals at the time. In fact, they argue in their papers that the reason that they weren't able to award contracts based upon the timeline set forth in the RFP was because of COVID, because of budgetary issues because of COVID. That's the same reason our client was unable to obtain the certificate. And I know I'm running out of time, and there's one other point I want to address real quick is, one of the other arguments that we make is that the decision basically saying that we did not meet this threshold review, the proverbial closing of the door in our face. Pursuant to the RFP, it says that that decision must be made by both the City of New York City Department of Health Mental Hygiene and their third-party contractor, PHS. There's no proof in the record that other than a statement in an affidavit and a copy on an email that that decision was made by both parties. And if that decision was not made by both parties as set forth in the RFP, then the decision essentially to deem our proposal non-responsive is arbitrary and capricious because they failed to follow their own rules and regulations.
Mr. Spencer, can I ask one more question?
Okay.
Counsel, did you seek leave to do discovery in Article 78 as one must?
No, we did not seek any pre-action or discovery or anything of that nature, Your Honor.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Amy McKenfield on behalf of the Respondent, Department of Health and Mental Hygiene. Your Honors, this Court should affirm the denial of the petition because, as petitioner admits, it did not meet the credentialing requirement of the RFP. And it's well established that when a bidder does not meet the bid specifications set forth in a agency's bid proposal, then the agency can deny that bid as
Counsel,
non.
didn't they actually protest the requirement before they even submitted their application?
Yes, Your Honor, and that, I was just about to get to that. And the reason why we know that the agency considered their request to submit a conditional approval is because they floated that to the agency prior to submitting the application. And the agency, Department of Health, and its contractor, PHS, responded and said, we've considered your request, and we've decided, after consideration, that only an operating certificate will be deemed responsive to this RFP. This RFP is targeted towards clinics that are in operation, and the petitioner did not have a clinic in operation at the time of the RFP, and it was not arbitrary and capricious for the department to therefore deem their proposal non-responsive.
And I assume that would be because if they already had a clinic in operation, that there would be no lag time once they got the award, that they would be able to be up and running very quickly.
Exactly, Your Honor. The point was to target the funding to clinics that could use the funding right away and serve these vulnerable populations. That's very clear in the terms of the RFP, and that's exactly what the Supreme Court recognized in denying the Article 78 petition here. Petitioners claim that the department's contractor acted unilaterally is unsupported. Both the department and its contractor have averred in their answers that they consulted together, and the record shows that because, again, we have the correspondence that the PHS wrote to the petitioner, copying the department, saying we've consulted with the department and we've determined that we cannot accept conditional approval. So we know that they consulted together on this. And for the reasons we've explained in our brief, also, Your Honors, there's nothing explicitly in the RFP or in the contracts that says that the contractor can't take the lead in making these kind of responsiveness determinations. That's precisely the kind of thing that the department hired the contract administrator to do. So there's no violation of the RFP here, and the department did not act arbitrarily and capriciously in denying this proposal as non-responsive, and we ask the court to affirm.
Thank you.
Thank you, Your Honors.
May it please the court, Anthony Green on behalf of Respondent Public Health Solutions. I'm not going to belabor a lot of the points that have already been made, but I would note that it was interesting to hear petitioner consistently acknowledge all of the reasons Your Honors raised for the critical accreditation requirement, that they made sense. Now, how is that not an admission of its rationality? And as far as making an exception to the requirement, well, they couldn't have done that. That would have violated the general municipal law. And with respect to the claim that it's not in the record, that the two parties consulted each other before the proposal was deemed non-responsive. In fact, there's a September 15th, 2020 email from Public Health Solutions to petitioner stating that after careful consideration with the DOH-MH, we have concluded that not meeting the requirements set out in Section 2A23 of the solicitation would indeed render an organization ineligible to bid. So as of that time, petitioner knew that its proposal was not going to be accepted, that it would be rejected, and yet it still did not bring this action within the 4-month statute of limitations from that time, in addition to showing that indeed the two did consult. Unless the court has any other questions,
Thank you.
Thank you.
The practical effect of the position that has been taken by the respondents ignores the reality of the world.
I mean, I think we get that this was going on during COVID and that you were trying to proceed and it may have been delayed like most everything else was. However, it's a very high standard, I don't have to tell you, in an Article 78 to find that an agency who routinely is reviewing these applications makes a determination that's arbitrary and capricious. I mean, you might have liked them to wait for you, but they were looking for someone who already had accreditation that was within their guidelines. What's arbitrary and capricious, even though if it's unfortunate, as you feel towards your particular client, which I'm sure does good work like so many others.
Well, I think what's arbitrary and capricious is that they essentially proverbially closed the door in AHF's face in light of the world that they were living on and did not even consider beyond essentially the first page of their proposal. We're not asking for a contract to be awarded. We're not
No, I
asking for
understand, but
funds to be
don't they have
provided.
the right to sort of, list what they think is important for them?
Yes,
And
I agree. They have the right to list what they think is important for them, but the rationality of their theory or their philosophy is that if any providers out there was in the process of obtaining any of these approvals that were set forth in this RFP, and because the world basically came to a screeching halt, you can't get that final sheet of paper, which we got before any contracts were awarded, it was irrational for them not even to look beyond the first page. And we don't know if we would have been awarded a bid, but all we wanted to have is that us to get a fair shake and to review our proposal. We provide excellent services. That's not an
But
issue.
I don't understand, when you say a fair shake, the fair shake is everybody who had certification at the time they applied got treated the same. So I don't understand I understand COVID was unfair to everybody and to varying degrees. So you were not able to, you weren't able to complete your application, maybe because of COVID, but
because
I don't understand what's not fair about that.
the approval that we had obtained essentially in the healthcare parlance, all that we needed to get next was basically a site inspection. And that couldn't happen. That's all that we needed. And what's also interesting, Your Honor, is that in the RFP itself, it talks about that following an award of essentially a contract or a bid, you still need to negotiate the contract. There's all of these additional obligations that need to be done before there's actually a signed written document. That may be after a bid is awarded. So if they would have just followed the time frame and the schedule which they built here, they didn't award contracts until after March. I don't know exactly when they did. That's when our record kind of stops. But in January of 2021, we had approval in hand. They could have looked beyond the first page and give us a fair shake. That's all that we want in this case, Your Honor. And thank you very much for your time. Have a good afternoon.
Thank you all. Hoy versus New York State Division of Housing.
Mark Davies for...
Counsel, I have to ask you to put your mask up, please. Thank you.
Apologies. Mark Davies for petitioner appellants Justin Hoy Lozano with Zakolsky and Zakaria. Essentially, this case is brought pursuant to Article 78, which was denied by the lower court in this matter. During the course of the administrative proceeding here, the law changed. The HSTPA came out in June of 2019.
Right. So the question is whether the apartment was lawfully deregulated before the HSTPA's effective date, which was June 14, 2019, correct?
Exactly. And a final order was not issued on this matter until more than a month after that.
And you say that it wouldn't be final until the PAR was issued, right?
Yeah, until the decision on the PAR came down, the apartment could not and was not deregulated, and thereby the change in the law would have prevented it from ever being deregulated under a high-income deregulation because it simply no longer
Well, you
existed.
can also bring an Article 78 about a PAR, right?
No, actually, you can't bring an Article 78 until you've completed your PAR.
Yeah, but I'm just saying, couldn't you say that, oh, well, we don't have a final deregulation until the Article 78 judge has ruled? Couldn't you say that just as easily as the assertion you're making here?
I believe you could also make such an assertion in this matter, but at the end of the day...
So would you have to wait till the appellate division ruled on it as well? In other words, there has to be a PAR and then an Article 78 in the Supreme Court, and then the appellate division has to rule on it before it's actually final? And then, or maybe you wait until you seek leave to appeal to the Court of Appeals, or seek cert to the U.S. Supreme Court.
But I think there is one important distinction and differentiation, which isn't mentioned in the papers here. A landlord, after he gets that par decision, may then start a housing court action to actually evict or cancel the lease based upon the fact that it is no longer regulated. Now, don't get me wrong, that court will then stay such an action for a final determination, but at that point, the action can be brought. So there is a distinction, there is a difference between those 2 points in this matter. And in this one, we did not have a deregulation. There was a very clear automatic stay pursuant to.
Well, you had the deregulation. There was a rent administrator's order that was on June 22nd, 2018. And that was an
No,
order
there was
that.
an order for deregulation, Your Honor, which is different than an actual deregulation of the apartment.
It said the subject housing accommodation is deregulated effective upon the expiration of the existing lease, and then the existing lease expired on November 30th, 2018. That was before the HSTPA was in effect. So you say there was nothing there, but there was clearly an order.
Well, in this instance, even though there was an order, that order is automatically stayed pursuant to the Rent Stabilization Code, Section 2529.12.
I'm glad you brought up that section, because I didn't see anywhere in your papers to the Article 78 court that you raised Section 2529.12. Was that raised below?
I am uncertain as to if it was raised below. I apologize. I was brought in yesterday to argue this matter due to
Counsel, that's not our problem. But if it wasn't raised below, and as far as I can tell it wasn't, and you're not able to tell me that it was, we can't consider that now, can we?
Well, such stays are automatic, regardless of, we never had to
If you didn't raise that issue to the lower court, we can't consider it under our jurisprudence. Wouldn't you agree?
Well, we raised this argument to the lower court. Whether we brought up that specific section in relation to that, I feel it should still be a vast consideration of this
Where in your
court.
papers did you raise that to the Article 78 court?
Again, I'm unaware of exactly where in the papers that may have been raised. Now, but even if that was not raised, the fact is that there was no final decision. There was no legal deregulation. The actual statute in the HSTPA is incredibly clear to the point that it must be a legal deregulation. And at this point, it had not been fully legally deregulated.
Sir,
yes.
I'm not sure I read 2529.12 quite that way. I think what it means, and it has different subparts to it, is the effect of the DRA order. And you raised that good point about whether a landlord can go into court on a holdover based on deregulation. You're correct that you can't rely on that order to act going forward, but the order is what it is until it is either reversed or affirmed by the par decision, correct? Because if that's true, you have different other subsets, say, for example, an overcharge order by the DRA. The landlord's filing of a par would stay the retroactive payment. So again, they're different components. It's the effect of the order. It doesn't necessarily mean the order just disappears.
Well, nobody's saying that the order disappears. It's simply a matter of the statute in the HSTPA clearly claims on legally deregulated. It had not been legally deregulated until a final order had been issued, and that's what we're saying here. The statute does not say you have an order that allows for deregulation. It says legally deregulated. It's very clear and concise in its language, and it even had a cleanup provision in Section 8, Part D, to ensure that it was very clear and concise that there are no more deregulations due to high rent, high vacancy income.
Thank you.
Thank you.
May it please the court, my name is Sandra Joseph for the respondent, DHCR. The court is indeed correct. It wasn't mentioned about 2529.2 in the Article 78, which provides that pending par, the order shall be stayed. In this particular case, Section 8 of the HPSPA said that anything that was deregulated is deregulated. This court has also repeatedly said in Serdarsky, which was reversed on other reasons, that in a deregulation order, it's just stayed, it's not vacated. This court further said recently in Harris versus Israel concerning an appeal where pursuant to HIPSPA, it was an order of possession, like this order of deregulation, and it said that when there is an appeal, you can't vacate the order, and that's what you would be doing if you vacated this order of deregulation. Thank you.
May it please the court, my name is Dejan Kizinovic. I'm counsel for Respondent 433 West Associates LLC. Rather than belabor the points that were raised about the HSDPA, I do want to address briefly the evidentiary record in the underlying proceeding, which is also being challenged on this appeal. To that end, I'll go into the brief overview of the evidence based on which first the DHCR and then Supreme Court determined that Mr. Hoy, the petitioner, did not in fact leave the subject apartment in November 2014, as he claims, and based on which DHCR and Supreme Court ultimately decided, yes, we're going to calculate his income as well for the purposes of the household income, for the purposes of reaching the deregulation threshold. It's 6 sets of evidence, and I'll go one by one very quickly. In his April 22nd, 2016 response to landlord's income certification form, Mr. Hoy stated that Mr. Lozano, the other petitioner, was his roommate, and he's marked his own status as A, which acknowledges that the apartment is his primary residence.
Counsel, I have a question to ask you about that. I noticed that petitioner's counsel stated in his papers that Mr. Hoy had made a mistake in writing the letter A, but there's no sworn statement by Mr. Hoy to that effect, is there?
No, there is not.
I was just wondering if I'd missed it. Okay, thank you.
No, there is not. Then in his July 25th, 2017 answer to landlord's deregulation petition, Mr. Hoy again indicated that the apartment was his primary residence by again indicating his status as A. Then in both of his 2014 and 2015 tax returns, which I believe the DHCR deemed to be critical evidence, Mr. Hoy listed the apartment again as his residence for his mailing address. Then on December 1st, 2016, this is, mind you, 2 years after he purportedly moved out of the apartment, he signed a 2-year lease, renewal lease, and indicated specifically that Mr. Lozano, the other petitioner, was his roommate. In his December 13, 2017 petition for adoption of Mr. Lozano, he also resides the apartment as his residence. Lastly, from November 2015 through June 21st, 2018, based on key fob data the landlord has obtained, where we can track who entered the building at what time, suffice it to say that this data is consistent with both Mr. Lozano and Mr. Hoy residing there permanently on a day-to-day basis, basically entering the apartment every day and exiting every day.
Thank you.
Thank you, Your Honors.
One matter I would like to rebut and raise in this is the idea of retroactivity. So previously, counsel stated that deregulation became effect essentially before that final order of the court. And the case that we brought up, 60 East 84th Street versus the DHCR, clearly stands for the fact that deregulation is prospective in nature from when that final order is issued. So the final legal deregulation is something that moves forward in time from the final decision, not from the initial decision.
Counsel, let me ask you a question. If a tenant had filed a PAR on a deregulation claim and had basically said nothing in terms, in the paragraph in the par form where it says, what is your basis? If the tenant just said, I'm appealing it because I don't want to be like deregulated, and filed that par, would that be sufficient to activate the automatic stay?
Such would honestly be a question for this court, I guess. I
I'm
mean, I've never
asking,
been
I
presented with
understand,
anything
I
like
know
that
that, but
before.
I'm asking what you think about that.
Clearly, in this instance, we brought forth a proper and valid objection. If the court wished to negate a stay based upon an improper appeal, I don't think that's the instance here. And that's really the only answer I can give to that. I apologize. As far as what Mr. Kujanovich has brought up, this was an arbitrary and capricious decision in relation to Mr. Hoy being out of the apartment. In 2014, he came down with a medical condition that would...
But in 2017, he swore in a court document that, in which he was stating his wish to adopt Mr. Lozano, that his residence was at the apartment. Allegedly, almost more than 2 years after the date you claim he moved out full-time. So don't we have to take very seriously that sworn statement he made to a court about the fact that in 2017 that was still his residence?
I can certainly understand the court's position on that. A layman's perspective on what it meant by residence, though, he was still filing his taxes from there as well. He didn't understand the term legal residence. He used it for much of his mail and mailing, and he had lived there for more than 25 years, and his son was still living in that apartment for him to collect the mail, and therein lies the issue is he may have attested to, yes, this is my residence, without understanding the full legal implications of naming it as his residence.
Thank you.
Thank you.
Thank you all. Bradbury versus Israel.
Good afternoon, Your Honors. Morel Berkowitz for the appellants John Bradbury and JBMI LLC. The court below inconsistently and erroneously dismissed claims for breach of fiduciary duty, tortious interference with prospective business relations, unjust enrichment, and unjust enrichment against a number of the defendants. The heart of this case...
Why don't we start with the tortious interference?
Yes, Your Honor.
Because I think in all of those, you charged, the claim was brought against Mr. Israel, but Mr. Israel was one of the parties.
We did not appeal that dismissal.
Don't you have a cause of action for tortious interference with a contract against Mr. Israel?
Well, it was included in the count, but we specifically did not appeal that dismissal of that cause of action against Mr. Israel. We have appealed the dismissal of the prospective interference with the prospective business relations with MIT and the Newmark defendants.
So wouldn't MIT be part of that as well, since MIT was Mr. Israel? I mean,
Well, it's a separate entity. It was a pre-existing title company which benefited from the joint venture engaged in by Mr. Israel and Mr. Bradbury. And if I could direct the court to page 78 to 79 of the record, which is really the heart of the case. And what that is was the uncontradicted written proposal made by Mr. Israel to Mr. Bradbury proposing a plan. And if you look at that, and I'll just do a couple of the highlights, get other lawyers involved as speakers and have them pay for their involvement. They did that. They had a program of speakers.
Well, that's why the court left in right? The breach of
No,
contract cause of action.
exactly, Judge. But by explaining just 4 or 5 points from that, and I could summarize, I'll give you the highlights. They created an entity called JBMI.
Right.
And as the record reveals, JBMI was the acronym for John Bradbury.
Was the two
Mark
of them
Israel.
together? We know that,
Okay,
yes.
so they created the entity, they paid, JBMI paid Mr. Bradbury over $235,000, and that's on pages 947 to 59 of the record. They issued a K-1 to Mr. Bradbury. That's on page 901 of the record. They used Mr. Bradbury's materials, and we have like it's 158 to 933 of the record, his materials. And in that proposal, which I say is the heart of the case, Mr. Israel says we should use these materials because they were already licensed with the New York State Division of Licensing Services. We could get up to speed right away. Takes too much time to have speakers develop their own courses. And in essence, yes, Your Honor.
I'm sorry. You keep focusing on this, this prospective business relations. What specific wrongful conduct did is MIT do to a third party that prevented the plaintiff, your client, from dealing with the third party, which is what tortious interferes with contract is. There's a third party here. So Newmark was the third party, so to speak.
Yes, Your Honor.
Where MIT sold his business to them, and JBMI was no longer getting dividends from the title business, et cetera, et cetera. Oh, and separately from the breach of contract.
I'm dying to answer that question, Judge.
Okay, separately from that. So my point is, sir, what was the wrongful conduct? What relationship did they interfere with between JBMI and some third party out there? What was that?
Newmark and MIT benefited from the wrongful means committed by Mr. Israel, and that they took his course materials and they used it for their programs. That was Mr. Bradbury's life work. For 10 years before he ever started this joint venture with Mr. Israel, he taught his own continuing education courses. He was a solo practitioner doing real estate transaction work. His main source of business and promotion was this program that he taught with over 40 or 30 different courses. They stopped using JBMI, and when Mr. Israel sold MIT to Newmark, they took all of the materials, they took all the speakers, they took the heart of the thousands. He taught 10,000 attendees. They took all of that. The judge below sustained the looting of assets cause of action, sustained the entitlement of an accounting. And as the cases we've cited in our brief, this court has held that if you benefit from, the phrase was unjustified means, no, wrongful means, excuse me, that alleges a prima facie cause of action for intentional interference with business relations. The second major mistake the court did is that it conflated the claims by Mr. Bradbury with the claims of JBMI. His claims were separate and unique from the claims of JBMI. The final thing that I just want to say is that the court also said, well, it was terminable at will, and that was the same arguments made by Newmark. It wasn't terminable by will. There was no dissolution of JBMI. If any statute applies to this arrangement, it's the LLC law. It says what's required. Mr. Bradbury was a 50-50 owner of the business. There was no dissolution or termination of anything. Mr. Israel just sold the main assets of JBMI when he actually sold MIT, and Mr. Bradbury was cut off entirely. The major asset that was taken was his website, NYRE Law, that was in existence for 10 years. He contributed that, which was the main way that they communicated with presenters and attendees, and he's frozen out of that website that he created. And if you look in the record, you'll see a joint publication of the NYRE Law website and the MIT Land Services website. And they bragged about it to give it credibility. This is the website we're now using.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Christopher Malazzo of Carmel Malazzo and File LLP, and we represent the respondent, cross-appellant Mark Israel. Just briefly on the issues of the tortious interference with business relations. First off, the court should note the appellant did not appeal from that portion of the order. It just appealed from the portion of the order that granted the motion to dismiss the third cause of action, which was for tortious interference with business relations against MIT. Didn't appeal that specifically in the notice of appeal. That's a waiver. Number two, as Your Honor noted, the wrongful means for a tortious interference with business relations case needs to, the wrongful means need to be directed at the third party. Here, the third parties that the appellant is claiming were these presenters, and this is where the business came from. There's not an allegation in the second amended complaint that alleges any wrongful conduct against these third-party presenters. So therefore, that claim fails. The court properly dismissed that claim as well. And as I'm not going to go through the other reasons set forth in my brief, I'll rely on my papers for that. Now, as to the fourth and seventh causes of action, fourth cause of action is an individual claim for breach of fiduciary duty against Mr. Israel. Seventh cause of action is an unjust enrichment claim against, individually against my client, Mr. Israel. Now, these are derivative claims. If you read the complaint, they're almost carbon copies. There's an individual claim for breach of fiduciary duty and a derivative claim for breach of fiduciary duty. Same with the unjust enrichment claims. They're almost carbon copies of one another. And if you look at it...
So were the derivative ones left in?
The derivative ones were left in because that's what the complaint alleges. The complaint alleges a harm to JBMI, that the assets of JBMI were misappropriated or diverted. That's what it claims. And if you look at it, really what it is what they're claiming is that it was these course materials, it was the list of presenters that Mr. Bradbury had previously produced that were contributed by Mr. Bradbury to the alleged joint venture. That's what's alleged. That's now, if it was contributed to the JBMI, which is alleged in the second amended complaint, then it's a harm to JBMI. And it's the harm that's going to govern who has the standing to bring the action. And here is clearly JBMI, not Mr. Bradbury in his individual capacity. At the best...
Are you still contesting the validity of the contract that was created in this case?
We are, Your Honor.
So doesn't the plaintiff have the right to, at this stage of the litigation, to plead in the alternative?
Well, but not for these claims, I don't think, Your Honor. There's clearly, if there's a breach of fiduciary duty claim, the way it's alleged in the second amended complaint is a derivative claim. It's harm to JBMI. There's no dispute that JBMI was formed, and it was formed, they were formed as 50-50 members.
Right.
But the way it's pled as they're pled as derivative claims, and there's no harm alleged. At best, you have alleged individual claims that are embedded in those derivative claims. And as a result, courts dismiss claims where they're embedded. Now, finally, on the cross appeal. For there to be a valid joint venture, there has to be a concrete offer, as with any contract. There is no concrete offer here. If you read...
Is it your claim that the November email, together with the course of events, doesn't create a concrete offer to create?
It's not the following course of events now, it's the email. What Mr. Bradbury is claiming in the complaint.
Well, can't we also look at the course of conduct after this? I mean, they worked for a few years doing everything very consistently with the email outline. And it wasn't, just an outline, it was a pretty detailed email at that.
Well, I don't think so. I think what you need
'Cause I have it in front
initially,
of me.
I'm sorry, Your Honor.
Go ahead.
What you need initially is you actually need a valid offer. And the alleged offer here is what the title says. It's his thoughts and to-do list. That's not a valid, concrete.
But they actually came together and then formed the LLC, and then they transferred the profits. So, and they talked about what would happen, that they would get the losses if it was profitable. So it actually came to fruition.
I mean, I'm sorry, didn't your client, I mean, didn't the plaintiff, didn't you pay the plaintiff?
I'm sorry, I didn't hear you.
I'm sorry, didn't you pay the plaintiff almost $250,000?
He did pay the plaintiff over time. But there still has to be, I mean, that was in relation to JBMI, there still has to be a valid, the complaint alleges a joint venture. And there was no valid agreement. Now, the other important.
It even says you and I, I'm reading right out of the email, you and I, meaning Mr. Israel saying to Mr. Bradbury, you and I should be 50-50 owners of that entity. And it's a 2-page, pretty detailed document, and Mr. Bradbury claims that he agreed to the terms.
Well, Mr. Bradbury does allege he agreed to the terms, but.
And then Mr. Israel sent accountings to Mr. Bradbury that reflect that agreement that Justice Kapnick just described, the 50-50 split.
Well,
right?
He did
that
send
did happen, right?
He did send accountings, whether it detailed that. But I think the important part here is if we're going to rely on that as the agreement, that needs to be an agreement to share profits. I'm sorry, an agreement to share losses. And that is an essential element of a joint venture. And if you look at that email, it shows that Mr. Bradbury will not share losses. It shows that Mr. Israel would be the sole one to bear any expense that didn't come in and wasn't at the ready at JBMI to be paid.
Thank you.
So there was.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. David Paul on behalf of Newmark Partners and MIT National. First, with respect to Newmark, Newmark does not belong in this case at all. Newmark is a stranger to the dealings between the plaintiff and the defendant, Mr. Bradbury, Mr. Israel.
Should there not be discovery for Mr. Bradbury to be able to determine if there was any relationship between Mr. Israel and Newmark that should be able to come to light, that discovery might bring to light?
That's still a possibility based on the posture of the case. The complaint was dismissed without prejudice as to Newmark, which is the correct decision by the trial court. If in the event discovery develops a claim that is actually cognizable against Newmark, the plaintiff will have the opportunity to pursue that. But the law doesn't work the other way around. The law does not allow the plaintiff to articulate an invalid claim on its face and then pursue discovery in the hopes to supplement that and create a viable cause of action. So the trial court got that issue exactly right. And I believe plaintiff mentioned in his appellate papers that he was denied discovery along the way. That's absolutely not true. Under the commercial division rules, discovery was not stayed during the pendency of the motion to dismiss. He just sat on his rights. So there is absolutely no statement or allegation whatsoever about Newmark being involved in the party's course of conduct other than the fact that Newmark bought a business. And so at oral argument, when the trial court asked plaintiff's counsel, what is your client's relationship with Newmark? He said, quote, we don't have any. Newmark, my client didn't have any relationship with Newmark. So there's zero connection between Newmark and the plaintiff, let alone the close, sufficiently close and non-attenuated relationship necessary for an unjust enrichment claim. So count 7, the unjust enrichment claim was properly dismissed, and that decision should be affirmed. Additionally, the equities involved in that claim further dictate that it should be affirmed because there's nothing inequitable about dismissing a claim against a buyer of a business. The tortious interference claim was also properly dismissed against Newmark. That is count 3. Justice Shulman, you properly pointed out that nowhere in the record is there any allegation of any improper conduct directed toward a third party. That is true for both Newmark and MIT. So that deficiency is fatal to that claim. There's an additional reason why these tort claims should be dismissed, and that is the fact that the underlying contract is alleged to have been indefinite in its term. The email is silent as to duration. That's the email that forms the basis of the business between these two folks. That is silent as to duration, and so therefore, under New York law, that contract is terminable at will and can only form the basis of prospective damages with a showing of malice. Malice, under New York law, means fraud, violence, deception, patently improbable acts. And there is nothing in this record that describes anywhere close to the malice requirement under New York law.
Counsel, it follows then that the fact that the LLC did not have a termination date doesn't matter, right? It's the contract that was terminable at will, and that's what governed the party's conduct.
That's exactly right. The LLC law is a red herring. The LLC law talks about the duration of the life of a corporate entity. It has nothing to do with the business dealings or the contracts between the parties, which is actually the question in the case. And so the tort claim fails for that independent reason. A third reason that the tort claim fails, and this also relates to count 2, which is the tortious interference of contract related to MIT. This was the question posed at the outset of the argument, and that is that Mr. Israel and MIT are one and the same. Remember that the plaintiff alleges that Mr. Israel is the sole proprietor of MIT. That's in the record at 87, and so it's impossible for MIT and to tortiously interfere with a contract to which it's a party. So that's another reason why the tortious interference claim count 2 should be dismissed. Finally, I see my time's up. I just want to correct one thing in the record with respect to the duplicative nature and the derivative nature of the unjust enrichment claim. The direct claims survived, which is the proper analysis under Udell, this court's decision, which is on all fours with this case. The question is, when the court needs to choose between a direct cause of action and a derivative cause of action, the analysis is which entity or which plaintiff suffers the cause of action and would receive the damages. The answer to that is JBMI. That is the entity that received the revenues and then distributed it to the equity holders. And so the court below got that decision right too. And the decision is to dismiss the derivative claims, which includes count 7, and allow the direct claims to continue. Thank you very much.
Thank you.
Very quickly, points 2, 3, and 4 of our reply brief explain and show the difference between the claims that are individual to Mr. Bradbury and the claims that JBMI have. As for what we appealed, page 3 of the record shows our notice of appeal. Page 2 of our reply brief shows all the causes of action that were upheld and the causes of action were dismissed. As to the claim that we were supposed to share 50% of the losses and the agreement doesn't specifically say that. I mean, granted, there was no formal written answer, I approve, let's go, let's make money. But the judge herself found, as your honors have noted, that this agreement was not just based on the 2-page agreement, but by their 6-year cause of action. And the judge concluded that, I believe, correctly. And in terms of the 50-50 loss, look at the K1. The K1 says 50% of profits, 50% of losses, 50-50 of partners. So that's not an issue either. And as to the issue of discovery, we should have done it, we waived it. We did not have discovery. And in my opening statement, I said the judge inconsistently ruled on things. When the judge ruled on Mr. Israel's motion for summary judgment, she said, well, we haven't had any discovery here. It's not enough. And on the very same evidence, on our causes of action, which the judge granted dismissal of, she didn't find any questions of fact. Oh, it was premature or too early, which is what we argued below. You can't have it both ways. Either it's inconsistent and you need discovery, or insufficient and you need discovery across the board, or it isn't. And we believe, and we outlined that in our brief ad nauseum, how the judge just erroneously said it was dismissible at will or terminable at will. There isn't even a termination of this agreement anywhere in the record. There was no dissolution of the partnership. They just stopped, he sold the business, and we were left out hanging. And in fact, one of the causes of action is they didn't even pay us for the time period that they made payments for. They only made payments of transactions through October 2017, and the record shows there were transactions after that. Thank you.
Thank you. Okay, thank you all. Fisher versus Centene Corp.
Good evening. My name
Good
is Jim
evening.
Fisher. I'm supposed to make an opening statement, so
So you're pro se, so why don't you just tell us what it is you want us to know and do?
yeah.
Okay,
Well,
in your own words.
the best way to summarize this, I think, would be that even if we assume for a moment that everything that Fidelis has said is true, we still have an issue of a $10 error out of a $7,000 to $8,000 annual premium not really being a material issue. It's a de minimis thing. It's not grounds for termination. And that's where this agreement went off the rails from a purely contract standpoint. In addition, the prescription that they withheld was for a drug that cost less than $10. So it's very small amounts of money here, and you have to wonder, why would a company do that? Well, the answer is my gray hair. I'm old. Older people tend to use more health care. Centene has an incentive to jump on any opportunity to terminate anyone who might cost them money. And if you read the news right now, they're having the same problem in California with their Magellan subsidiary and in Florida with their Sunshine State Health Plan subsidiary, which was just fined $9 million for withholding approvals on prescriptions. So this is a business practice for Centene. And my being caught up in it was just my bad luck. So that's why we're here, over $10.
Thank you.
Thank you.
Good afternoon, Your Honors. Christopher Porzio for the respondents, New York Quality Healthcare, Inc., DBA Fidelis Care, as well as Centene Corp. Your Honors, in his presentation, the appellant, Mr. Fisher, failed to address the reason and basis for the lower court's decision and order here, which granted the defendant's respondent's motion to dismiss under CPLR 3211A1 and A7 and denied Mr. Fisher's motion for leave to amend, and that is the complete absence of any damages suffered by Mr. Fisher as a result of the alleged termination of his insurance that he's complaining about in this case. And so to put it in context, Your Honors, this is a case where Mr. Fisher is claiming that Fidelis Care improperly terminated his insurance coverage, but he's admitted time and again in pleadings before the trial court and in his briefs now that he had no medical claims during the 5-month period at issue here that would have been covered by insurance. And given that situation, Your Honors, as the trial court held, plaintiff admits he has no medical claims for which to seek reimbursement and therefore has no cognizable injury upon which to sue. And that was the case in his initial pleading, in his amended complaint, as well as in his proposed second amended complaint that obviously the trial court refused to grant leave with respect to because it found implicitly that the amendment was futile because that same issue of the complete lack of damages continued. So while Mr. Fisher may be frustrated with Fidelis Care, he has no claim because he has no damages. I'll also note that this was a situation that what Mr. Fisher characterizes as a $10 error was a situation completely of his own making. He purposely, pursuant to his pattern, waited until the last day of the 30-day grace period. The premium at issue was due on August 1. He purposely waited until August 31st. He always waited until the last day of the month.
He could do that, can he? I mean, I'm sure he's not the only person that does that.
No, but when you do that, you assume the risk of not properly paying, which is what occurred here, and you assume the risk of the contract being lawfully terminated for non-payment of the premium. And that's what happened here. So if he had tried to pay it on the first day of the month and when it was due, and if he had realized the error, he would have had time to cure it. Instead, he didn't do that here. He waited until the last day, and when it was underpaid, the contract of insurance was lawfully terminated by Fidelis Care.
But while you view his conduct in waiting to the last day to be unreasonable, he views your conduct, your client's conduct in terminating his insurance for the absence of $10 to be unreasonable. So isn't there some sensible resolution to this?
Well, Your Honor, what I would say is whether it's someone may subjectively feel it's reasonable or unreasonable, the fact of the matter is the contract is very clear that the premiums have to be timely, paid in full. So there's really no meaningful dispute here that under the terms of the contract, Fidelis Care had the authority and right to terminate for his failure to fully pay the premium. And whether Mr. Fisher subjectively feels that that's unreasonable or not really is beside the point, because he admitted to the conduct that gave Fidelis Care the basis to terminate the contract of insurance.
Thank you.
Thank you.
Okay, Mr. Fisher, you have 1 minute to tell us what you object to in terms of what counsel said.
First off, on the issue of payment, there is no evidence concerning a late payment in any court proceeding. We asked them for their payment ledger. They refused to produce it. The payment ledger will, in fact, show that I was paid ahead several months. I went through in my reply these same kind of arguments of my own making and paying at the end of the month. No, I was paying at the end of the month to pay for a month in the future. The payment made at the end of August paid for October. I was paid well ahead. And that's been in the complaints from the get-go. There's no evidence from them to refute that, and this is a motion to dismiss. So what's in the complaint is assumed to be true, and I don't see why Fidelis is allowed to introduce, without any support, a claim that a payment was late. They've provided no such evidence. They had the opportunity to do so. And, you know, the rest of it is in my reply. That's probably much better worded than I could do. Thank you.
Thank you very much. Thank you both. I'm going to call Murphy next, and then Home Depot will be last. Murphy versus Chimenti Construction.
I forgot which side I was on.
Thank you for calling us. Good afternoon, Your Honors.
I would have called you anyway, eventually.
On behalf of Alan Russo, from Russo and Gould, on behalf of the third-party defendant, Dame Construction. The issue before the court on this appeal is actually fairly straightforward. As I advise all the attorneys who work in our office, you only make a motion for summary judgment if there's a viable basis for the motion. It is not our responsibility to burden the court with unreasonable motions that have no chance of success. And in this particular case, the associate who drafted the papers in the court below followed that instruction. And based upon prior decisional law in the First Department, made the reasonable conclusion that there was no reasonable chance of success in moving for summary judgment in this case, based upon the current state of the law in the First Department. About a month after the decision in the case of, I'm sorry.
Krzyzanowski. Let's just call it Krzyzanowski.
Okay. Came down where this court specifically cited the Singh case, which was the case that we were initially relying on, and saying we declined to follow that decision based upon the Court of Appeals decision that was several years earlier.
Counsel, didn't we previously find in Conlon versus Carnegie Hall that the integral to the work defense did apply under the relevant industrial code section?
That is correct, but in the Singh case, the court specifically held it did not apply. And in the Carnegie case you mentioned, Your Honor, I don't believe the court specifically declined to follow the decision in the Singh case. So at a minimum, the law in this department was...
No, I think we mentioned Singh in Conlon, but I may be mistaken. I thought we did. And said that something along the lines that to the extent that Singh held otherwise, it shouldn't be followed. I thought that's what we said. Or maybe that was in Krzyzanowski. That was in Krzyzanowski. Pardon me, counsel.
Well, but the thing is, am I wrong, Mr. Russo, but the Krzyzanowski case, which you're kind of relying on for what you did here, was published or issued by us more than 120 days after the, after the plaintiff's filing of the note of issue, right? So
Correct.
you waited, it was a lot longer than you were supposed to make a motion. Anyway, you could have, you could have made it and said, well, Conlon goes one way and Singh goes another. We want you to reconsider it, but didn't.
Well, I mean, look, the law was unclear. Once the Krzyzanowski case came down, the law became crystal clear. And especially the facts in Krzyzanowski were almost identical in the sense that the integral to the work specifically involved masonite, which was the gravamen of the action in this case, was the placement of masonite. In Krzyzanowski, the court specifically held that masonite is integral to the work, and to the extent that there's a claim under Section 217, I believe it's 2173(1)(e).
4.7 E1 and E2 are the ones that we're talking about here.
Correct.
Right?
Right. So under E1, for the first time, this court clearly stated and clarified that under E1, the masonite, if it's used for protecting flooring, is considered integral to the work. Therefore, as soon as we saw that decision, within 30 days, we made a motion.
Of course, Krzyzanowski also holds that the boards can be applied in a negligent way, right? It doesn't it's not the case that under Krzyzanowski that if you have masonite, then it is per se integral to the work and therefore defeats a cause of action under 241 sub 6, right?
Well, what it does say is that it applies to 241.6, and that under the facts of Krzyzanowski, it said if masonite is used for the protection of the floor, which it was in this particular case, then it clearly is integral to the work.
Right.
On the issue of negligence,
Krzyzanowski lived on. In other words, the case continued because there was a question about whether the masonite was properly used in Krzyzanowski. They found an issue of triable fact about that, correct?
Well,
we did.
On Krzyzanowski, the issues remain with regard to negligence, or Section 200. There's no claim of negligence against my client, and indeed, my client would not be responsible. There's no proof of any negligence on Dame Construction. The plaintiff was an employee of Dame. It had no responsibility for placement of masonite. And indeed, I think the plaintiff, I'm pretty sure, testified, and it's in the record, that the masonite was placed by Shimenti, who's the third-party plaintiff, who's got a claim against us, and was initially installed by them all to protect the floor. We had no control over that. So any claims of a 200 violation against our client or a negligence claim are not borne out by the record. That's why it's so important that if the 241.6 claims are dismissed, there really should be no liability against our client, and the third-party complaint should also be dismissed.
Thank you.
Good afternoon, Your Honors. May it please the Court, Michael Zhu, Appellate Counsel, the Shorts-Apple Lawyers. The issue before the Court is really simple. Whether Krzyzanowski and cases prior to that held that the integral to the work defense is applicable to 23-1.7E1 and 2. I can go as far back as 2006 in O'Sullivan versus IDI. I had the third-party defendant on that one. I won in that case. This court held that the conduit pipe that the plaintiff tripped over was integral to the work, affirmed the dismissal of the trial court, and this court's decision was affirmed by the Court of Appeals.
Does E1 deal with passageways and E2 doesn't?
Correct.
So
Yeah.
this case has nothing to do with the passageway.
Correct. My case deals with E2, workplace,
Right.
A work area. So to the extent that the argument is that Krzyzanowski says that the defense is applicable to an E1 case, it's irrelevant.
It's not really relevant to
Correct.
this.
That was an argument that we raised below and on appeal.
Right.
Then this court, again, in 2018, in another case, Saginaw versus Friars, I lost that one as a plaintiff. My client tripped over a metal frame that was on the floor, and it was in a hallway. This court held that that frame on the floor, which was supposed to be used for sheetrock framing, was integral to the work, and dismissed my 23-1.7 E1 and E2 claims. That's 2018. That's 2 years before this court's decision in Krzyzanowski. And then on top of that, as Judge Moulton said, you have Connellan. Same factual scenario where you have a trip and fall on an object that was integral to the work, and this court held specifically that it applied to a 1.7 E1 and E2 claim.
How the heck are you going to win on this case? I mean, I know. I mean, isn't that a little problematical for the
No,
facts of this
not at
case?
all. Not at all. Because factually, if you look at my client's testimony, and it's very clear on this, he tripped over a masonite board that was placed on top of a plywood board that was on top of tile and flooring. The masonite, everyone agrees, was put down to protect the tile floors. There was also testimony that sometimes masonite was used as a ramp to allow a pallet jack, the wheels, to roll over nicely. But that's not what happened here either. My client said that the masonite board was on top of a piece of plywood. Now, and the testimony being that you only put masonite board to protect the tile floors, there's an issue of fact here as to what that piece of masonite was doing on top of a piece of plywood.
Can I ask you, I mean, I know there's a whole thing about whether we should even deal with the merits of this case because of the delay in bringing the summary judgment, and he tried to explain why, but in any event, the 240 subsection 1 case,
Gone.
There's no 240.
No 240.
This really has nothing to do with E1, right? Because nobody's claiming this is a
Correct.
passageway. So this would just be a 241-6 claim as to the E2.
And also a 200 common law negligence.
Right.
Not necessarily against Dame, but certainly against the GC. And I would submit that, although, because it was raised before just now, on the 200 and common law negligence, they never met their burden on summary judgment. Even if you were, but you shouldn't even get to that because there's no new law on the 200 and common law negligence issue. You shouldn't even get to it. But if you were to reach it, I would say that you shouldn't even reach it on the merits because they didn't establish their burden as the moving party to establish the absence of actual or constructive notice. Because there's no testimony in the record. Thank you.
All right.
I believe, as Judge Katnick, you pointed out, the reality of the situation is he has no viable claim under either E1 or E2 against our client. So the fact that the motion
I
was...
just asked that question doesn't mean we ask a lot of questions.
Yes, no, I understand that. But as far as the negligence and the 200 claims are concerned, there is absolutely no proof that Dame Construction was in any way negligent or violated 200 of the labor law. It had no ability to control the use of the masonite. So I don't see how we could be, when I say we, I'm referring to Dame Construction, can be held liable under that theory. And the same is true with a negligence theory. We didn't touch the masonite. So this really goes, in fact, and lastly, to the contractual indemnity claim that's being brought against us. If plaintiff, and we cited it in our brief, it's an acts or omissions clause, so there has to be some proof of negligence against our client, and there is none. And secondly, if the two code violations are out based on our motion, then the argument that a violation on behalf of Dame Construction was triggered the indemnification agreement, my argument would be, then that would be out as well, and the third-party complaint should be dismissed. That's why this is so important, as far as my client is concerned.
Thank you.
Okay, thank you very much.
Home Depot versus State of New York, and Justice Moulton is recused from this case.
May it please the court, Ronan Doherty on behalf of appellant and claimant Home Depot USA. This is a case about insurance coverage, and thus the question presented is what must the insured prove to win indemnification under an insurance policy? In Prasker,
In this instance, to get to the point, it's grave injury, right?
I'm sorry.
Yeah, that's my question. Here, grave injury has to be determined before, under this policy.
Not for coverage, Your Honor. Grave injury was an element of the claim in the main case, but grave injury is not an element of the claim for coverage. The claim for coverage is simply a claim for breach of an insurance policy that the fund admits covers a claim for common law indemnity based on grave injury. And so in this case, to prove coverage on summary judgment, which is what we're here on, the claimant, or the insured, need only prove that the insured has been held liable on that covered claim. And so once we understand what has to be proved in this case, we have two ways to get there. First, in the Rivera case, the underlying main action, after the Second Circuit appeal on which the fund so heavily relies, the Rivera court issued a decision that says nothing about the Second Circuit ruling negates the scope and force of Home Depot's judgment based on common law indemnity. So that means as we stand here today, Brian's, the insured, is liable on that 2018 judgment for common law indemnity as well as contract indemnity, and it's also liable for attorney's fees on common law indemnity. And so,
Sir, I'm sorry, but in the main action that you refer, correct me if I'm wrong, but when the Second Circuit reviewed the lower court's decision, it acknowledged contractual indemnification between Home Depot and Brian, but it never reached the question of common law indemnification, I guess, because it didn't have to, correct? There was no ruling on common law indemnification, correct?
There was no Second Circuit ruling on the question of common law indemnity. But with respect... But you're trying to suggest here that somehow there's collateral estoppel on that question, no? So let me be very clear. On the 2018 judgment, Home Depot does not argue that anybody is collaterally estopped by that.
Are you talking about the district court or the Second Circuit?
I'm talking about when the Second Circuit decided the appeal without addressing common law indemnity.
Yes.
That means that 2018 decision has no collateral.
Yes, I understand what it means, but it was also a 2018 decision. You just said 2018. You didn't distinguish whether you were talking about the district court or the Court of Appeals.
I'm sorry. So
the Second Circuit.
As a consequence of the Second Circuit's decision, the 2018 judgment lacks preclusive effect. It doesn't collaterally estop anybody. But that's not where the case ended. We came back to the district court and litigated the effect, the continuing effect of the 2018 judgment on Bryans. And Bryans is the insured. It is Bryans' liability that matters here in this coverage action. And what the Rivera Court confirmed in 2021, so years after the appeal, just last year, that judgment, the 2018 judgment, continues to bind Bryans, separate and apart from collateral estoppel. As a matter of law of the case, in Rivera, Bryans is liable today for common law indemnity. And that is all that's required to show coverage. Now, Home Depot does rely on collateral estoppel today, but not for the 2018 judgment, for that second 2021 decision, where the fund represented Bryans and litigated whether or not that judgment continued to apply. That decision was never appealed and is the Rivera Court's final word on that liability. That decision does bind the fund via collateral estoppel.
So are you saying that grave injury doesn't come into this at all? Because it seems like what you're saying is that under the policy, common law injury has been found, but that's not where it ends here.
I'm not sure I understand your question, but let me try. So grave injury is not an element of the claim for coverage once the insured shows that it's liable on a covered ground. Now, that had to be established in the first case. It was very important in the first case, but it's not an element of the policy. The words grave injury don't appear in the policy. The policy covers any type of liability permitted by law, and that's broad and comprehensive. One of the ways that that Bryans could be liable that way was via grave injury and common law indemnity.
Okay.
But that doesn't mean you have to reprove the elements of the underlying case in the coverage case. And let me try an example. If a doctor gets sued for malpractice and loses a jury verdict based on negligence, all that doctor has to do to get coverage under their medical malpractice policy is show that they're liable. The doctor doesn't have to switch sides, come in and argue before a different judge, yes, I really was negligent. Yes, I really did hurt that plaintiff. We don't see those types of cases because that's not the objective in the coverage case. You don't relitigate the negligence and the causation in that second case. And that's really flows from Prashker, which says that the basis for the liability in the main case is what governs whether or not there's coverage. Allowing relitigation the second time allows for different results. Here, Bryans could be held liable for grave injury and common law indemnity in the main case, but not have coverage based on different facts in the second case. Prashker rejects that result. My time's up.
Thank you.
Good afternoon, Your Honors. Miriam Skolnick from Hertzfeld and Rubin. I represent the State Insurance Fund. I think that counsel is omitting words from the policy, which basically limit the coverage. It does cover common law indemnification, but only where recovery in common law indemnification is permitted by law.
And what does that mean?
That means the workers' compensation law, section 11, says you can only recover in common law indemnification where there is a grave injury.
So grave injury does matter here.
Pardon?
Grave injury does matter here.
Grave injury is an integral part. Here, the Second Circuit could have affirmed on both contractual and common law.
And it didn't touch the issue with regard to common law.
Right, and it understood that that meant that that finding of grave injury, and it specifically said we're not reaching the issue of grave injury. They didn't just say we're not reaching common law. Meant that it had no collateral estoppel effect, which means the issue had to be retried. Now, the Second Circuit couldn't send it back for a retrial in the district court because they had just affirmed the judgment, which was for contractual indemnification. So really, where we are now is exactly where we should be. We're in the Court of Claims, where now, in order to obtain coverage under this policy, Home Depot has to show that recovery is permitted by law. They've conceded that
how would they do that? Do they? I mean, the case is over. The plaintiff has a judgment. How does the defendant now has to prove that plaintiff suffered a grave injury by producing documentation? And the Judge Sy said that was not produced to him in Court of Claims.
Right, so Judge Sy said you don't have summary judgment, but there will be a trial.
I mean,
And
there's documentary evidence here. I'm sure that there could be a physician's
yes,
affidavit, whatever, with all of the information. It's as simple as that.
it's as simple
If it
as that.
exists.
If, in fact, Home
If it
Depot
exists.
believes the evidence is as overwhelming as they say it was, then they can simply present the same record. They want to present additional record. Plaintiff is still available. In fact, Home Depot has had him examined by a physician.
And the state insurance fund has no obligation under the contract to indemnify Home Depot at all unless there's been a finding that there's that there's common law indemnification, which could only exist if there was a grave injury.
If there is
Contractual indemnification that the Second Circuit ruled on doesn't affect this insurance coverage.
And the same is true with regard to Judge Kodal's decision on the attorney's fees, because the fact that law of the case applies doesn't really bind the state insurance fund, which is exactly what Judge Sy said. It's Home Depot's motion for summary judgment. They had the burden, and they just didn't meet it on summary judgment, but they haven't been thrown out of court. At this point, the issue proceeds, and when and if they prove that there was a grave injury, then they'll have coverage. There's been no disclaimer here, and everyone's fully protected. Unless the court has any questions?
I just want to make sure, thank you. I just wanted to make sure that I wasn't thinking about another case when I said grave injury was relevant.
Okay. Thank you.
Thank you.
So none of the cases that the fund cite involve retrying the medical evidence of grave injury in the coverage case. The way those cases turn out are usually because the main case isn't over or there's a settlement. And
Well,
so,
look, I mean, I agree, cases come up in funny different, ways, and the facts are there. This case has come up in this particular way. It took me a while to figure out what it was about myself, because there are a lot of different proceedings, but here we are now, and you have a contract that only requires them to cover you, or a state insurance fund is only required to cover you if there's common law indemnification. The only way they can be liable under common law indemnification is if the plaintiff suffered a grave injury.
Is that correct? I want to know from you. Is that correct?
under common law indemnity, that is correct. But
Okay.
let's be very clear. There has been a court finding of grave injury to Mr. Rivera. That still binds the insured. So today, Bryans is liable for $9 million.
Where is the court finding of grave injury?
I mean, that is in the Rivera court record. That is the order that was appealed.
In Southern District?
In the Southern District, that's exactly right.
The one that was appealed, where the Second Circuit only affirmed the contractual indemnification and ignored the issue with regard to the common law. That case you're talking about, right?
That's the case I'm talking about, but it did not stop there. In 2021, that same court said that Bryans remains bound by the 2018 judgment for common law indemnity. Bryans can't get out of that, no matter what happens here today. Bryans is liable on a covered ground, and that is all that's required to establish coverage.
Thank you.
Thank you.
Thank you both.
The journey continues. They're interested. They feel like, and the issue is the amount, right?
Where are we up to?